YouTube to spin up. I'm going to respond to the 7 people that have texted me at least at this point to tell me the stream's not up. Or I'll just clear them out. So actually, I'm going to put my phone on silent is what I'm going to do. Wait on that. Because otherwise people will bother me. There. All right. Are we good to go? Are we streaming? Thank you, sir. Appreciate that. All right. It is 8:07 Eastern Time, calling this hearing of the Judicial Committee to order. Apologies to those who have been waiting patiently, including those here with us. We had to get some technical things sorted out. Those have been sorted out. To start this hearing, we did give both sides the opportunity. Obviously, the appellant side filed their brief. The respondent side filed their brief. There's been a number of amicus briefs. We have a format for this hearing. Just so everyone knows, the hearing, we're going to give 15 minutes to the appellant to speak first, 15 minutes to the respondent to speak second. This is up to them what content they want to present to this committee. Then there'll be a period of 30 minutes is set aside for questioning the appellant, 30 minutes questioning the respondent. This committee does have the ability to vote to extend time if they so choose. And then we will end with a 5-minute close from each side, starting with the respondent and finishing with the appellants. The appellant will get the first word and the last word. Since the burden of persuasion is on them, it's only fair to give them first and last words that they can persuade. We're going to start this with me reading the motion that the LNC passed, as that is the topic du jour for this hearing. And so the motion that was passed on May 25th by the LNC reads as follows. The bylaws are clear that affiliate parties shall not endorse the candidate of another party. Despite this, the Libertarian Party of New Hampshire openly and publicly endorsed President Trump during the election. Furthermore, they have crudely and repeatedly undermined our own candidates and have espoused numerous anti-libertarian positions on a national level. Be it resolved that because of these reasons and more, the Libertarian National Committee moves to disaffiliate the Libertarian Party of New Hampshire, mandating that they cease and desist the use of the party name and logo until such time as the LNC recognizes a new affiliate in New Hampshire that shares our party's foundational values. That motion was proposed, and it passed 15 to 2 to 1. Just to make sure we're all clear on that. And also, when I read this, I said President Trump, but when it was verbalized at the hearing or at the meeting, it did say Donald Trump. That's irrelevant. But just to be very clear, so we're all clear on what was done. This did pass 15 to 2 to 1. It met the threshold of 3/4 of the entire committee, which was required. And those are basically the facts of where we're at. With that, we are now going to move into, the rules of decorum. Hey, treat this like an actual court. Like, let's treat it with some respect is basically the decorum here. Those that are participating, it would be beneficial to everyone, including themselves, I believe. So yes, so we are now into the opening statements. Mr. Hewitt, the floor is yours for 15 minutes. The time I see as 8:10, so you have, I just turned to 8:11, so you have till 8:26 and you don't have to, by the way, neither party has to use all their time. Completely optional. So.
Mr. Molman, if I could, before I start my opening statement, a quick procedural request of you. The instructions do not specify witness time, except that I see they say with leave of the committee. So I'd like to request leave of the committee to allot 10 minutes each to 2 witnesses, Mr. Kaufman and Mr. Hubbard, and 5 minutes each to Ms. McCardle and Mr. Weir. And if I could, I would like to call those witnesses after my opening statement, but before the committee questioning of me, for the reason that a few of the witnesses have some time constraints. Angela McCardle has to deal with a newborn baby, and so I would ideally like to dispose of the witness testimony before we move on to the 30 minutes of questioning.
Okay, those darn children always getting in the way. No, I'm joking, by the way. So I don't know that we had time, 30 minutes, because that adds up to 30 minutes of time for the witnesses themselves. I don't believe that we had time set aside for those witnesses. We'd have to talk to the committee to get an approval of that. So what I understand you're asking for is 15 minutes for the opening from you, Mr. Hewitt, and then 30 minutes worth of testimony from those witnesses before we would go into 30 minutes of Q&A.
Or in the alternative, Mr. Chair, if I could have some guidance as to the total amount of time I might be allotted for witnesses altogether, so that I know how much to divide between each witness.
Okay, so it was our intent that your opening statement was your free-for-all for anything you wanted to use, which includes witnesses or anything to that extent. So that was
I
our
see.
intent. If that is not enough time, if you feel that that is not enough time, I can ask the committee if they'd be willing to extend the time for you for your opening statement period before we get to Q&A. I can't answer whether or not they would be willing to do that, but I can make that motion. We can ask the committee.
Well, I would love to call some. I would love to address the substance, the bylaws, and the Roberts Rules questions. I think that will require some time before your questioning to raise some substantive arguments. And since there was no underlying factual adjudication, I would love to call a few witnesses. So I would request leave of the committee to do a 10-minute opening statement at least, and at least 20 minutes in total of questioning of witnesses.
Okay, so that's 30 minutes instead of 15, basically, for what we had allocated for a 15-minute opening statement is essentially what we would be looking at there.
If I understand correctly, that there is
Yep.
no alternate way to call witnesses other than by sacrificing my opening statement, then that's my request.
That is correct. Yes, Ms. Hewitt. That was the intent. So I'm going to ask right now of the committee, is there objection to extending time for the opening statements from 15 minutes to 30 minutes for each side? Is there any objection to that?
I object.
Okay, Mr. Dixon objects. So,
As do I.
okay, and Mr. Goldstein objects. All right. So let's do this. There's an objection. So let's go ahead and take a vote on this real quick. Dr. Moulton, are you in a position where you're able to take a roll call vote? I know we weren't necessarily planning on that, but are you in a
Sure.
position where you could do that?
I can do that if you all want.
Okay.
Do you want me to do that now?
Restate the question, please?
The question is whether we will extend the opening statement period from 15 minutes to 30 minutes, and we'll give that to both sides. So again, it's optional how much they want to use, but extending the time to 30 minutes for opening statements for the appellant and the respondent instead of 15. We're increasing the time from 15 to 30 for both sides. So I don't know that we really need discussion. Mr. Hewitt gave his explanation on why he would like that. I don't know that anybody, unless somebody really wants to discuss it. I see Mr. Dixon and Ms. Jingle both have her hand up. Is that for discussion or is that for?
I'd just like to hear some rationale from both, or either Sam or Pat.
So I mean, I can re-summarize. Oh, you want to hear rationale for why they don't want to extend?
Yes, yes.
Okay.
I'll be happy to. We don't have time. We've sent out the procedure. The most important part of this, in my opinion, is our ability to question. We've reviewed a lot of these briefs. That time needs to be preserved. We cannot be extending time this much.
I agree with what Pat said. We set time limits for each party, and we are not in a position to extend this much beyond what our end time is anyway. So that's why I'm going to vote against this proposal.
All right. I'll just quickly speak in favor of it because I think it's this is a big deal, guys. I don't know if you know this, but like this is from what I've been able to research. This is the first time that there's been an actual true disaffiliation of an affiliate in 50 something years, right? Like there's been constructive disaffiliations over fights over leadership and stuff. I'm not worried about a half hour. So that's my take on it. And why I say I will be voting in favor. So.
Could we also hear from the respondent's spokesperson on this matter, since they're involved in this?
If there's someone on the respondent side, Mr. McGee, is Mr. McGee here?
Yes.
I'm sorry, you're under LNC secretary. I apologize. I was looking for your name. If there's no objection, let's hear from Mr. McGee on the matter.
Personally, I'm actually not opposed to extending time. However, I will not be using the additional time.
Okay. All right. Thank you, Mr. McGee. So with that said, then, is there any other further discussion on, this is basically a motion to extend time for this period from 2 15-minute periods to 2 30-minute periods. Any other discussion? Seeing none, let's go to a vote. Dr. Moulton, if you wouldn't mind.
Yeah. Ms. Jingle? Ms. Jingle?
No.
Yes or no?
No.
Okay. Ms. O'Brien?
Yes, extend time.
Mr. Neal?
Yes. Sorry.
Mr. Dixon?
No.
Mr. Goldstein?
No.
I will vote yes. Mr. Molman?
I will vote yes.
Time is extended. I'm sorry. There are 4 yeses and 3 noes.
All right. With that, then the motion passes. Mr. Hewitt, you have a total of 30 minutes to present your opening argument and your witnesses before we hear from the respondent side, who will also have the same opportunity, though they've expressed that they won't take that much time, whatever. It's their time to choose how they use it. And then obviously we'll continue with the rest of it where we'll go into Q&A. But you have 30
Can't
minutes.
put in a personal privilege real fast.
Yeah. Yes, sir.
You want to remember we had a discussion about interjecting some personal time in this meeting.
Yes. Okay. So I'm sorry. I should mention that as well. So, and actually, since we're doing 30-minute opens, we might do one after. The committee talked about taking short breaks in between each thing, just so we're not here on a 3.5-hour death march. That we actually have some time to relax and get thoughts together and whatnot. I think that benefits everyone involved. So at the end of each period, now that we've extended to 30 minutes, I think it makes sense that we would maybe take 2 or 3 minutes at the end of each 30-minute period, at least, if not 5. We'll play it by ear, but just so everyone knows what to expect, that we'll take a break after each period so that, yeah, we can chill out for a minute. So, all right. With that said, I'm reading that it is 8:19. I'm going to guess that by the time I quit talking, it's going to be 8:20. With 30 minutes, that'll take your speaking period, Mr. Hewitt, to 8:50 p.m. Eastern Time. And so you are welcome to begin when you are ready.
Thank you, Mr. Chair. I'd like to first put our position on the record with respect to 3 different issues that I don't intend to focus on in my opening statement, but I want to make our position clear on these 3 issues. First, I filed or attempted to file a reply brief with some supplementary evidence attached. I will attempt to introduce that into the record once I've called a witness later in this statement. However, to whatever extent that additional pleading and evidence was rejected, we wish to put our objection on the record to the rejection of that pleading under JC Rules 2.9 and 2.3, which contemplate multiple kinds of briefs, documents, and supporting evidence, and because we are the party whose rights are at issue in this hearing. Secondly, we want to put our objection on the record to the committee's rejection of 2 filings by groups of 6 to 10 Libertarian Party affiliates in support of LPNH, a separate brief in support of LPNH by the Libertarian Party of North Carolina, and a brief by the Libertarian Party of Hawaii. We object on the record to those 4 rejections for the reasons stated in my reply brief and the 10 affiliate amicus brief, and we would ask, although we know the committee can't take it up at this moment, that the committee reconsider under Robert's Rules 61.9, as this is a disciplinary proceeding, the rejection of those amicus briefs. And lastly, I would note that we do agree on the merits with Mr. Cizilke's amicus brief that a quorum is required to fill JC vacancy seats. We don't plan to focus on that issue otherwise, but because some amici were confused about our position, we wanted to be clear on that. And we do think that this committee should read amicus Cizilke's arguments and consider formally the question of whether the quorum requirements in the bylaws govern vacancy appointments before it reaches the merits in this case. So I'd like to talk now about social media. And I hadn't planned to talk about social media, but the reason I want to focus on this a bit in these first 10 minutes here is that I noted that the LNC intends to call a witness to speak to discussions between some LNC members and LPNH that happened in 2025. And the content of those conversations was focused only on social media conduct, not on the Trump endorsement. So I do want to discuss the question of whether social media conduct not defined in this motion or during the LNC meeting at which this vote happened can be the basis for a disaffiliation motion. As you all heard Chair Molman read a moment ago, the motion alleged generically that LPNH has undermined candidates, that it's expressed unspecified, numerous unlibertarian positions. There isn't a shred of specificity about that within the four corners of the motion to disaffiliate LPNH. As we documented it in our petition, there was not even, believe it or not, there was no specificity about that at the LNC meeting at which this vote occurred. You can listen to that entire recording. At no point does someone quote a single tweet or statement prior to voting on this motion. There were motions to enumerate lists of particulars that were rejected. And one LNC member in opposing one of those motions said, quote, "I may not have a list of particulars, but we all know what's been going on up there," unquote. Even the LNC's respondent's brief, which we think, by the way, would be clearly too late to give notice of cause, included exactly 2 social media posts. And those were both posts by Jeremy Kauffman, made in his personal capacity, that did not even address LPNH. So I'd like to give a couple reasons why any evidence or argument that relies on LPNH's social media posts to sustain disaffiliation are really beyond the pale of what it's appropriate for this committee to consider. And one reason is, first of all, there's a lot of discussion in the pleadings about the Roberts Rules of Order understanding of for cause. But without even looking at the Roberts for cause standard at all, we can just look at party bylaws 5.6. And bylaw 5 says at least 3 pertinent things. It says the LNC shall have the power to revoke for cause. It says that the motion to revoke for cause must specify the nature of the cause for revocation. And it says that at the hearing, the burden of persuasion shall rest upon the appellant. Now, there's at least a couple of interpretive principles from Robert's rules that we should bear in mind when we're trying to make sense of what those requirements mean. And just one of them that I want to highlight here, since I want to abbreviate this statement a little bit, is Robert's Rules 5669(2), which says that when an interpretation of a provision renders another provision absurd, then the alternative interpretation must be taken as the true meaning. And the reason that's important here is because if some general statement like unlibertarian positions and undermining our own candidates, if that can be the basis of alleging with specificity the cause, then the idea that the burden of persuasion is on the appellant, who is us in this hearing, is rendered completely absurd. It has essentially no meaning. That concept of the burden of persuasion being on the appellant really presumes that the appellant has an opportunity to rebut a definite allegation. And the burden of proof provision there has no meaning if the disaffiliation motion can just say this affiliate consists of bad people doing bad things, and the affiliate then needs to wait for a hearing to find out what that is. And it doesn't help, I think, if the affiliate is supposed to read through a dozen, 24 different amicus briefs, 6 or 7 different Harlos briefs, some briefs which I couldn't conceivably have had an opportunity to read because some briefs were posted, within the past few hours. If those amicus briefs, if there's some thought that somehow those constitute sufficiently specific notice of what the wrongdoing is, then the idea of the burden of proof being on the appellant is rendered absurd. And the other the other concern here I'll just note quickly is that this committee's opinion in Phillies, where it was applying the Roberts for cause standard, it pointed out under that standard, an accused has the right to be apprised precisely of the conduct in which she is alleged to have engaged in order to prepare her defense. And so no matter where you look to define, for cause, and this was an application of the Roberts for cause standard, but whether you look at Roberts, you look at legal cases or something else, for cause is always a limiting principle on the disciplinary authority. It's not an empowering principle like at will. And if that principle prohibits you from doing only one thing. It prohibits you from saying, these are bad people doing badly bad things, and that's why they should be disaffiliated. So we would ask that under JC Rule 2.8, that the committee reject and strike written or verbal content that purports to use LPNH's social media content as a basis for sustaining disaffiliation. That's true because of 2.8a. It's outside the committee's jurisdiction because it has not been noticed. As I said, it wasn't even in the respondent's brief. And under K, because K says the committee can strike and exclude anything that fails to comply with the rules and bylaws. And the entire structure of the rules and bylaws presume notice with specificity of specific wrongdoing. Now I'd like to talk for a couple minutes about the Trump so-called endorsement vote. So 61 through 63 in Robert's rules is an integrated whole, and we focus on, and especially in the respondent's brief that I'd like to introduce, we focus on why this concept of for cause in Roberts is a substantive requirement of what Roberts calls the basics of a fair procedure, where there's notice and there's an investigation, there's an opportunity to be heard, and there's findings. But something else that I want to point to here is that the JC rules and the bylaws provisions that talk about this JC, they are full of words like appellate, and appellant, and these sorts of words. And if you look at any authoritative definition of what appellate is, like a Black's Law definition of appellate always presumes that there was some underlying adjudication. Appellate presumes that this isn't a court of first impression. You all mentioned at some length just a moment ago, this committee has limited time. You want to hear a narrow set of issues. You don't want this to function as some sort of quasi-investigative committee where you hear extensive questioning of lots of witnesses. That's something that should have happened in an underlying adjudication. And, an interpretive principle, I've mentioned a few of these from Roberts. One is 5668, 2 through 4, which says you should presume the words in the bylaws were chosen with some purpose. So all these words like appellant, appellee, we should presume these were chosen with some specific purpose. They're not just random words that are synonyms for procedure or something like that. And a couple of other separate arguments are that a background principle in Robert's rules is that there is basically a fair disciplinary process. 63:7 says these are the basic elements of a fair disciplinary process, and these steps must be followed in the absence of specific disciplinary provisions in your bylaws. 63:7, it says must be followed. Now, again, 61 through 63, everyone agrees that the text of those rules is focused on members and on officers, but it talks at great length about the concept of for cause, and it says the norm in Robert's rules, which is incorporated in this party's bylaws, is that this is the basic default. This is a fair disciplinary procedure is the default. If you don't have something else, default to this disciplinary procedure. And then finally, there's a separate argument, which we highlighted in our initial petition, this initial Dixon committee created under this Jarvis motion in 2021. The LNC has responded here. Well, there was never a motion to kind of adopt the findings of this committee formally by the LNC, but the original motion creating this committee said it contained within it this idea that this was going to be a model for intervening in the internal affairs of affiliates. And it said that it had some of these elements of a basic disciplinary process, findings, recommendations, and an investigation. So because I would like to go to some witnesses, that's all from me on those topics for now, but I look forward to taking your questions. And I would now like to call, I think we'll go ahead and go with Angela McCardle, since she needs to leave soon. Angela, if you're still here.
Hi, I am here.
Fantastic. All right. Well, everyone just heard your name's Angela McCardle. Angela, what was your role in the party in 2022?
I was the national chair for the latter half of 2022.
And did you write a letter to the Libertarian Party of New Mexico in August of 2022?
Yes, I did.
Okay, and what was that letter about?
Believe the August letter was regarding Libertarian Party of New Mexico's illegal convention, why the National Party viewed it as illegal, and what they could do to come back into compliance.
Okay, and I'm going to ask the committee to accept on the record the document that we've entitled Petitioner's Reply Brief and Motion, which has this letter attached. I'm assuming, Mr. Molman, because of my limited time, I should not discuss this with the committee now, and we should take this up at some point after I've concluded my opening statement.
Sure. And by the way, and I'm pausing your time for a moment. You're more than happy, or we're more than willing to take your reply brief in this hearing. Any documents, any evidence you have to bring forward, this is the time to do that.
Okay. Well, I'd like to put onto the record the reply brief, which has this letter attached. This is the first exhibit on the reply brief that I'd like to ask Ms. McCardle about. This letter, what did you ask Libertarian Party of New Mexico to do specifically?
The August 9th letter?
Yes, the August 9th letter.
Just one second.
This was about, you said this was about their constitutional convention being invalid.
Yeah, I'm just looking at it because there were two letters I sent. I think in this letter, I think in the first letter, in the July letter, we sent more requests for them to come into compliance with their own bylaws and the national bylaws. And I think in the August letter, we talked more specifically about member rights, why we were getting involved, and addressing this issue with the Secretary of State.
If I said that I'm looking at the letter and you asked them to repudiate their July constitutional convention as null and void, and to recognize their previous constitution as their valid constitution, does that sound correct to you?
Yes, it does.
What next steps was the LNC discussing if the Libertarian Party of New Mexico did not comply with this letter?
Disaffiliation and trying to claw back ballot access via the Secretary of State.
And so disaffiliation was being discussed. What process were people discussing using to disaffiliate Libertarian Party of New Mexico on the LNC at the time?
Setting a meeting, setting an advance notice meeting.
And what kinds of things did people think were going to happen at this meeting?
Well, we would hear from the affiliate. We would hear from people in support of the affiliate. We would hear from people who supported disaffiliation. Essentially like a mini disciplinary hearing during the meeting.
In these discussions on the LNC, did anyone ever suggest, hey, we don't need to do any of this process. We can just vote right now and just unilaterally disaffiliate the Libertarian Party of New Mexico at will, or anything roughly along those lines?
I think that there were a couple of people who proposed that, and some of it was going to be discussed in executive session, which I won't repeat, but the majority of the LNC said that we had to give due process, basically, that we were not going to be able to quote unquote pull that off. It's not going to happen. People on the LNC weren't supportive of it. Members weren't supportive of it. It was going to go to the JAC. It was going to create potentially a legal issue, and that maybe one or two people thought that was fine, and maybe there was going to be an argument made via Robert's Rules of Order or some other governance policy that we weren't going to have to give them notice. But the majority of people didn't believe that, and didn't believe that it was going to stick even if we tried it.
What did the Libertarian Party of New Mexico do after you sent them this August 9th letter? What was the next step that they did?
They sent, I think shortly after that, they sent out a press release saying that they had disaffiliated from the National Party.
And did you know they were going to do this?
Not officially. I mean, I had an idea that they were going to do it because they'd been threatening it or there had been rumors of it. It was a few years ago, so I don't recall exactly, but I didn't know for sure that they were going to do it.
So how did the Libertarian Party of New Mexico announcing they were disaffiliating themselves bear on the subsequent LNC vote to say that the Libertarian Party of New Mexico is disaffiliated?
Well, that escalated and sped things up pretty quickly. That basically disposed of the majority of arguments saying that we were going to have anything like a disciplinary hearing or a trial because they were, improperly disaffiliating from the National Party. They were not going to cooperate with us. They were not going to fight it. They wanted to be disaffiliated.
Great. All right. Thank you, Angela. That's all for me for now. And because of the format of these questions, I suppose neither council has the opportunity to question each other's witnesses, I guess. Is that correct, Chair Mullen?
That's correct, at least not in this period.
All right. Okay,
Thank
Angela, thank you very much. I appreciate it. I'm going to ask Nick Hubbard to come up now. Nick, are you here?
Hello. Yes.
Hey, Nick. Thanks for joining us. When did you join the Libertarian Party of New Hampshire, and what roles have you had in the party?
I believe I joined spring or early summer of 2021. I think my roles were I was on the politics committee at one point. I was vice chair for 2 executive committees, and then stepped in as chair at the end of 2025.
Were you vice chair when Ryan Bloodworth proposed that the executive board vote to endorse Donald Trump?
Yes.
Were there different factions at the time represented within LPNH?
Yes.
So just one, we're a little pressed for time here, but one area where some libertarians in New Hampshire are divided on Trump, including among libertarians who identify as right-leaning, is on President Trump's trade policy. Where do you fall in that debate?
I'm opposed to Donald Trump's interventionist trade policies.
When you were vice chair and chair, were board members in general aware of your views on controversial issues?
I believe so, yes.
And did you support Bloodworth's proposal to endorse Trump?
No.
Do you have any reason to believe Jeremy Kauffman was instructing Ryan Bloodworth or the other board members to endorse Trump?
No.
Do you ever recall Jeremy Kauffman saying it would be a good idea for the LPNH to endorse Trump?
No, I don't believe that ever happened.
And after vice chair, you were the chair, right?
Yes.
Were you ever contacted as chair by the LNC about the previous Trump endorsement?
Not to my recollection.
Do you know if other LPNH board members were ever contacted about the Trump endorsement specifically by members of the LNC?
I don't know that. I'm sorry.
Okay. The LNC did not ask you to rescind or disavow the Trump endorsement vote. Is that correct?
Not to my knowledge.
Okay.
To my knowledge, that never occurred.
All right. And I've submitted to the chair and the secretary the 2024 bylaws. These were the bylaws that were in effect at the time that you were vice chair when this Trump endorsement vote occurred. Do you recall those bylaws say that candidates are nominated by the party at conventions and not by the executive board? Does that sound correct to the best of your recollection?
I don't recall. I'm sorry.
Okay.
I don't have the bylaws in front of me.
All right. Do you remember let me ask you this then. Do you remember the executive committee ever voting to decide any other candidate that LPNH was going to endorse?
I believe those votes occurred at the state conventions.
Yeah, that would fit. That would fit with the bylaws. All right. Thank you, Mr. Hubbard. I appreciate it. And I would like to bring up Ben Weir. Ben, if you're available.
Yep.
Great. Ben, fantastic. Thank you all so much for being so efficient. Ben, what positions have you held within the Libertarian Party of New Hampshire and when?
When I first moved here in 22, 23, I was, I believe, an at-large after my first term on the board. And then I did take a year off. And then in 2025 at the convention, I ran for chair and I got that position. And I held that chair position until late fall of 2025, where I had to resign due to other political obligations that were occurring at that time. I was also on various committees and on the Libertarian National Committee as well during that entire time.
You were on the LNC when you were chair, right?
Correct. Yeah, from 2024 to 2026.
And you were elected as chair after the Bloodworth board voted to endorse Donald Trump.
Correct.
And you have submitted an amicus brief, and you've spoken in that amicus brief about the fact that you were outspokenly and vocally opposed to the Trump endorsement. Is that correct?
Yeah, I don't think it's pretty public information that I was adamantly opposed to the Trump endorsement.
All right, Ben. And then while you were chair of the LPNH and while you were simultaneously on the LNC, did anyone on the LNC ever say that you had violated the bylaws or LPNH had violated the bylaws through this Trump endorsement vote?
They never implied that I was responsible for the previous board's endorsements. I remember it was spoken about on the LNC to some degree, but never in any kind of serious capacity in terms of reprimand whatsoever.
Did you have a meeting with Stephen Nikela? I apologize if I'm mispronouncing that. And a subsequent meeting with Jeremy Kaufman as well, and the vice chair of the LNC.
Yes, as well as the former comms director, Brian McWilliams.
In either of those meetings, did any of the LNC members ever bring up this Trump endorsement vote?
No, actually, the only things that were mentioned, we came up with an agreement between the LNC and LPNH, where we would stick by 3 rules as long as they weren't violated against us, and that was no inter-party attacks. We can stick to sophisticated disagreement on social media, and provide context when being controversial. There was nothing ever talked about in terms of Trump endorsement. In fact, most people were of the opinion that this was kind of a bygone, like it was not really anything that people were even thinking about anymore.
Was this, when you say agreement, was this some kind of contract, or was it just an informal discussion about how you were both going to proceed?
We had a verbal discussion, and amongst the LPNH board, we had an agreement of what we would submit to the LNC. And I submitted a letter to the LNC, which I can provide for the JC if they're interested. It is public, and it basically it talks about the entire conversations of everything that went down during those calls about communications on Twitter and stuff.
And it had nothing to do with the Trump endorsement vote?
Not even a little bit.
And you've said it was about not attacking other libertarians. Is that correct?
Correct. Yeah. Basically, no inter-party attacks, aggressive language, slurs, no right-coded insults, gay, retard, racist, incel, stuff like that, as well as calls for disaffiliation or removal of other party members from other parties and stuff.
And what happened to that agreement?
Well, pretty quickly after this agreement came out, we stuck to our guns, and we actually were following all these rules even well past the fact that we were getting attacked right immediately after it was released. And, we stuck to these rules for a good while, and eventually, we just kind of went back about our old ways there. But yeah, there was no mutual respect given, trying to come up with any kind of agreement there. We were basically extending our hand, but the hand was slapped away by many other party members.
All right. Thank you, Ben. Nothing further for now. Much appreciated. I'm going to ask Jeremy Kaufman to come up with the last few minutes here.
I'm here and ready.
Thank you, Jeremy. We just have a few minutes left. What positions have you held in LPNH and when?
I have been the chair of LPNH since our convention earlier this year. Prior to that, I spent a full term as secretary after being elected in our 2025 convention, and I served as interim secretary from the end of 2024 into the 2025 convention. Before that, I was the chair of the comms team for around a year, and then prior to that, I was just a comms member with other people acting as chair. So I've really risen through the party over the years.
And what was your position on the Bloodworth board's attempt to endorse Trump?
As someone who was not eligible to participate in that meeting, and as the first meeting I was ever on the LPNH XCOM, mostly took a back seat, I did have some concerns, specifically because of some of the things that are happening now. I do think that there is an obligation for the Libertarian Party to support Libertarian candidates, and as the chair of LPNH, that's the way I would like it to function.
Were you present for, sorry, and I need to ask first, did you personally think Libertarians should vote for Trump separately from your view on what the LPNH should have done?
I think that's a complex question that depends on your views as a libertarian and what you put primacy on and how you view voting itself. Some libertarians think that you should never vote for the lesser of two evils. Some libertarians see themselves, such as I believe Walter Block has made this argument, that you're trapped in a democracy and you should, in fact, just vote for the lesser of two evils, even if that person is not a libertarian. So this is, I'm well read on my libertarian literature. I've been a libertarian since as soon as I learned the word. And this is an area where libertarians have argued for a long time. Should they be purists or should they be pragmatists?
Do you agree with Ben's characterization that in these meetings with LNC members, the Trump endorsement was not brought up?
Not a single time.
What will it mean for the Libertarian Party as a national organization if disaffiliation is upheld?
Ken opened this meeting by talking about how serious and unprecedented this is. And I do hope that all JC members are considering this. Libertarians like to have these sayings about they're neither right nor left, or, we should fight the state, not each other. Every political test I've taken my entire life, and I will admit this is one area where my Twitter haters get me a little bit, as I keep taking these political quizzes, and they keep saying I'm a libertarian. Every single one I take when I give my answer says, Jeremy, you're a libertarian. And so I do see this as the LP risking tearing itself apart. I think this risks setting off a cascade of events that means that every convention is a fight about kicking out states so that various factions can control the party. It seems that the Libertarian Party itself now exists in this state where most of the time is spent fighting over who controls the party. And I think that's a really disastrous outcome. The LP is supposed to be built on these principles of decentralization, local control. I mean, even if you just imagine how libertarianism works, people have different cultural views, people have different social views, people put primacy on different issues. In a libertarian America, people are going to sort themselves out. Different types of people are going to live in different places. So yeah, LPNH can be a very right-wing voice. It can take different perspectives on issues where libertarians disagree than other libertarians do. But in any libertarian America, those people are still going to exist. And from the perspective of those who don't like us, it sure would be better if we all live in the New Hampshire gulag, then you're stuck living amongst us. So I think this risks some really bad outcomes. I think the people who are voting on this should think really carefully about it because I think it's not going to end here. I think it only will further tear the party apart over time.
Chairwoman, could Mr. Kaufman have 1 to 2 sentences to answer a final quick question?
With the indulgence of the board. Any objection? The board is not objecting. The committee is not objecting. Go ahead.
Jeremy, what is the status of Andrew Allgood's membership in LPNH?
Andrew Allgood has been suspended pending an investigation. You know, we take due process and doing things the right way very seriously. I would like the Libertarian Party. You know, I've been through the court system. My company library was torn apart by the federal government. And I think if there's a bare minimum that we ought to follow if we want people to respect us, is our court systems and our procedures should be better than what the federal government does and not worse.
Thank you.
All right. That concludes this period. Committee members, we had originally talked about doing 15, and then a break, but we then extended to 30 minutes. Is there a desire to take a 5-minute break here? I know I've been taking notes on all this and my hand hurts. I've been writing down things that I want to ask questions about or have been thinking about. Is there objection to 5 minutes right now?
Do it.
I'm not seeing any objection. We're gonna stand at ease then for 5 minutes. We'll return at 8:58 p.m. Eastern time. Thank you so much, Mr. Hewitt, and thank you for your presentation to your witnesses. Stand by. We're gonna let the LNC speak next, and then we'll hit Q&A. And to those watching this hearing, I guess I'm hoping that that's only people that are interested, because I don't know why else you would be watching this. Stand by. We'll be back in 5 minutes.
Just Mr. Molman, just so you're aware,
Yes.
the live stream will be continuing.
Yes.
I can't pause it.
Yeah,
So-
that is a great point to bring up to everyone, is the live stream is still live. Please mute yourself while we're in these breaks. It'll be better for everyone involved. Nothing embarrassing occurs if you turn off your camera and mute your mic. So that's what I'm going to do for the next 4 minutes. going to come on to say this is the 1 minute warning. We're going to try to keep this as tidy as we can because I have to work tomorrow. I bet most of you do too. Going to come on to say this is the 1 minute warning. I did that before, yes. Oh, that was a feedback echo. That was wild. That was a way delayed 1 minute warning. All right.
Sorry, that's the delay from our actual live one to the stream.
Okay. No, that was wild. Now we know how what the delay is. Okay.
Sorry.
I was like, wait, that's me. That's me saying that. All right. So we've got a few more seconds here.
Are you watching the stream, Ken, while we're doing this?
I am not. I believe Miss O'Brien is.
I was looking at it while I was like checking on the cats.
All right. It is 8:58 p.m. Eastern Time. Respondent side LNC, Mr. McGee, you were the lead, as I recall. Are you ready
correct.
to begin at this time?
I am.
Awesome. Let's go ahead. We're going to go ahead and kill just a little bit of time to make it an even 59 by my clock. So that way you get to 29 and some change since we let the other side go. If you want to go that long, you have it. If you don't, I don't think anybody here is going to cry. So use as much time up to 9:29 p.m. To make your case. And you may begin when you like.
All right. Members of the Judicial Committee, thank you. I won't spend too much time restating what has already been submitted to the written record before you. You've read the briefs. You've read the amicus filings on both sides. What has not been addressed, because it was very recently submitted, was the amicus submitted by Ms. McCardle. So I would like to address that head on first, as well as the testimony by her just a few moments ago. So first, I would like to start by saying that former Chair McCardle's account of the LP New Mexico issue is not disputed. She describes a month of written correspondence, a detailed letter specifying curable violations, and an opportunity for that affiliate to come back into compliance before any vote occurred. The LNC accepts that account as accurate, but her account answers a different question than the one before you tonight. Article 5.6 of the national bylaws has no notice and cure requirement, and the record shows that New Hampshire did receive warning prior to the disaffiliation vote. 8 months before the vote under review, this affiliate received a formal censure. That is not the same as what Chair McCardle sent to New Mexico, and the LNC does not pretend otherwise. But it is not silence either, and I would ask the Judicial Committee to weigh what actually happened here against what didn't. First, 12 months before the disaffiliation vote, as described by Mr. Weir, LP New Hampshire entered a voluntary agreement in which they themselves proposed rules against, I guess, quote, aggressive language slurs or insults towards party members. As a result of that agreement, LP New Hampshire avoided a censure motion that had been noticed by Mr. Bill Redpath for the in-person LNC meeting that occurred in Grand Rapids in May of 2025. As also heard by the testimony by Mr. Weir, at some point thereafter, they went back to their old ways. So that conduct did continue, and it continued well into September of 2025, where after having exercised previous restraint just a few months prior, the LNC moved to censure LP New Hampshire for the continued conduct at issue. After the censure, the same conduct continued, with some instances occurring mere days before the disaffiliation vote. As an aside, it is worth noting for consistency that regardless of the steps taken by former Chair McCardle in the case of LP New Mexico prior to the September 2022 vote to disaffiliate them, the plain language of the actual motion to disaffiliate LP New Mexico would not meet the specificity standards that the petitioner and supporting amici now demand of the motion to disaffiliate LP New Hampshire. Second, a great deal of ink has been spilled on the substance of what was actually said publicly on LP New Hampshire's own official account over an extended period of time. I will not read it into the record. The written submissions already do that at length. And I do not think this, what I will say is this: an affiliate is entitled to robust internal debate, to genuine disagreement with national leadership, even to sharp
We're not able to hear all his words. I don't know what can be done about that.
Mr. McGee, you're breaking up slightly, and we want to hear what you're saying. Is there a position or a place better in your home or wherever you are where you get better reception?
I'm sorry, now I'm not hearing.
Okay, here's what I'm going to ask. Committee members, can you turn your cameras off? I know that when we have problems with Zoom, sometimes it's a bandwidth problem. And I'm going to turn my camera off, and hopefully that'll help with Mr. McGee's bandwidth. Go ahead, Mr. McGee.
What was the last thing you heard me say?
We were talking about the censure for conduct, and the behavior continued, and then it started getting choppy.
Okay, then I'll back up. So again, as an aside, it's worth noting for consistency that regardless of the steps taken by Chair McCardle in the case of LP New Mexico prior to vote to disaffiliate them, the plain language of the motion to disaffiliate LP New Mexico would not meet the specificity standards that the petition now demand of the motion to disaffiliate LP New Hampshire. Second, a great deal of ink has already been.
Sorry, this is still choppy. I really want to be able to hear his words.
Mr. McGee, I apologize. There is an ability to dial in as well, and it would think, you know, if you wanted to do that instead, I think the committee would like to give you your full time and also be able to hear. My ADD brain can put your partial sentences together because I hear everything partially anyway, but not everybody thinks like that. Would you prefer to dial in? Is that better? Do you know?
I can do that if that's what the.
Yeah, because you just lost what the committee wants. It turned into unts, and that was what we heard. Like we lost a chunk of the sentence, which I put together. But again, you should be able to dial in. There should be a link there on the audio to dial in. I'm going to pause your time here. It happened at 9:04 is when we started losing you. Wouldn't mind dialing in. I see you coming into the waiting room.
Ken, also, are Mr. McGee's remarks in writing that he could post into the chat or something?
I assume that both parties will be giving us more documentation at the end of this, you know, evidence, and I hope that that will be there. But you know, this is the hearing, so I'd love to actually, you know, hear, because we're not going to read that tonight, right? That's going to be for us to consider.
Right.
But for the Q&A portion, I think it's good to hear this. Mr. McGee, are you with us, or are you able to speak now? Can we hear you?
Hello?
We can hear you, yes. Are you good?
Okay.
All right. I'm going to resume your time here. We'll just extend your time for about a minute, which is fine. So go ahead. Please continue.
All right. So, okay. Where was I? As an aside, it's worth noting for consistency that regardless of the steps taken by Chair McCardle in the case of the Libertarian Party of New Mexico prior to their disaffiliation vote, the plain language of the motion to disaffiliate LP New Mexico would not meet the specificity standards that the petitioner and supporting amici now demand of the motion to disaffiliate LP New Hampshire. Second, a great deal of ink has already been spilled on the substance of what was actually said by LP New Hampshire on their official account over an extended period of time, so I will not read it into the record. The written submissions already before you do that at length, and I don't think the committee needs it repeated out loud to understand its weight. What I will say is this: an affiliate is entitled to robust internal debate, to genuine disagreement with national leadership, and even to sharp criticism of this very body and its decisions. None of that is at issue here. What is at issue
is an extended pattern of public statements issued through an official party channel that go well beyond disagreement and beyond criticism, and that the Judicial Committee's own members have had the opportunity to review directly in the record before them. I will close with what remains true regardless of anything heard tonight about how New Mexico was handled. In November of 2024, Disaffiliate's Executive Committee endorsed a candidate of another party for president in direct violation of our bylaws. That is conceded. The question before you is not whether New Mexico received more process. It is whether LP New Hampshire received a fair process under what our actual bylaws say, and whether the conduct that followed the National Committee's own formal warning of the affiliate justified the vote you are being asked to review. Thank you, and I look forward to your questions.
Ken, you're muted.
Ken, you're muted.
See, I'm trying to be a good host, and I'm talking to no one. All right, so Mr. McGee's comments did not take a half hour. It is the prerogative of this committee. We had talked about having a break at this moment. Do you guys want to take a break right now, or you want to keep going?
May I ask a question first?
Of course, Dr. Moore.
I see there's several other LNC members here. Were they meant to be called as witnesses by Mr. McGee, or or are they just available for questioning later? I'm not
They're
sure what's going
available
on.
for questioning.
Okay. All right. So, committee members, what would you like to do? Would you like to take the break here, or we keep on trucking?
I would say we begin our questioning of the appellate, of the petitioner.
Is there objection to continuing forward and having the appellant Q&A session begin?
No.
Seeing no objection, we will begin. Committee members, I will ask you to raise your hand. I will call on you. Mr. Dixon has got his real hand up. So we'll start with Mr. Dixon.
Well, thank you. Mr. Hewitt, should I? Oh, I'm sorry.
I'm just going to note that we're starting this at 9:09 p.m. Eastern time. Sorry.
All right. Can I go?
Yes.
All right. Mr. Hewitt, should I refer to you as Mr. Hewitt or counsel, or how should I refer to you?
Mr. Hewitt's fine. Thank you.
That's great. Okay. Mr. Hewitt, so I'm going to ask a question, and I have other questions, but I'm going to pass the baton after this one. Okay. In your opening, you referred to some of the amici that questioned the validity of our committee. And if I understood you, you were saying you were joining their opinion that there wasn't a quorum, we're not properly constituted. And if we agreed with you, would you agree that we would end this meeting, not give a ruling, we have no standing, and the LNC action stands?
No, I wouldn't agree with all of that statement. I don't think the LNC action would stand. I think that the better argument is that it would default to a reversal of the LNC.
Well, it doesn't. Okay, so clearly, how do you come to the conclusion that the default would overturn the LNC? There would be no recourse other than this committee. So how does it default to overturning the LNC motion?
Because there is a default affirmance clause in the bylaws, and the default affirmance clause is very specific. It says that there's a 30-day period in which if this committee does not act after this hearing, then by default, the LNC's decision to disaffiliate us is upheld. And because there would need to be some kind of default decision if this committee could not adjudicate this issue, the only way there could be a default affirmance would be under that clause. And one reason I think we know this is true is this committee has taken a very firm stance on multiple different issues that where there is permissive language in the bylaws or rules, that permissive language is exclusive of everything else. So if there's permissive language saying sustaining members may file amicus briefs, that means no one else, no other organization, no affiliate can file an amicus brief. Permissive is exclusive. If it says LPNH may file a petition, that means LPNH may not file any other kind of pre-trial pleadings or briefings at all, but people can file many amicus briefs. That specific permissive grant is preclusive of everything else. So in the same way, if there's a permissive default affirmance saying that the LNC gets their default affirmance conditional upon this hearing and there being a hearing of a JC, the JC does not act in 30 days. That's the only way in which a default can be.
All right. Well, I'm going to pass the baton, but I see failure of the Judicial Committee to rule within 30 days shall constitute an affirmation of the National Committee's revocation of affiliate party status. There's an exception if it's before a national convention. So my interpretation is different than yours, but
that exception. Oh, I'm sorry, Mr.
If you want to respond, I want to pass the baton, but.
Yeah, the exception is to the default affirmance clause. And the default affirmance clause says the LNC's decision is upheld if this committee meets and does not act within 30 days. That is the only situation in which a default affirmance is provided for. And if there is no judicial committee, then there's no judicial committee hearing. Again, this isn't the argument that we would like to primarily emphasize, but since you asked about it, we agree on the merits with Amicus Borky's position.
I want to pass the baton.
Thank you. Mr. Chair, if I could quickly add, in case it is helpful to the committee, Mr. Kaufman is also available to answer factual questions, but I'm more than happy to continue to answer questions as well.
Mr. Hewitt, what I'd like to do is have the committee direct questions to you, the general questions anyway, to you. And if you want to defer them to other witnesses, that is your right to do so, if that's okay.
That's fine.
Okay. Mr. Goldstein?
Yes, I've just got a couple simple questions, Mr. Hewitt. The bylaws are clear that an affiliate party shall not endorse the party candidate of another party, correct? Yes or no?
Correct.
Did the Libertarian Party of New Hampshire endorse Donald Trump for president of the United States in 2024?
Well, I think
yes or no?
No.
Yes or no?
No.
They did not endorse that. You conceded in your original appeal that they endorsed Donald Trump.
There was an endorsement vote by the board. This isn't an argument I led with because I understand that it may not be the most persuasive argument, but we don't actually think that the executive board had the authority to endorse a candidate. The bylaws which were in effect at the time, which I've asked that be introduced into the record, say that candidates are endorsed at the convention and those must be Libertarian Party members. So
okay, then I've got a follow-up on question then. How did Chase Oliver get on the ballot in New Hampshire? Did the Libertarian Party of New Hampshire effectuate his ability to be on the ballot? Yes or no?
I don't know the answer to that question.
The answer to that question is no, I believe.
Ian,
you can defer to Mr. Kaufman.
You can defer to me.
Yeah.
Yes. The Libertarian Party of New Hampshire both allocated substantial money to ballot, signature collection for a co-ballot that included Chase Oliver and our governor candidate. We allocated, I believe, something in the $6,000 to $10,000 range for that, and many LPNH party members participated in the activity of getting Chase Oliver in the ballot. It is absolutely and unequivocally true that the Libertarian Party of New Hampshire helped Chase Oliver be on the ballot in 2024.
I've no further questions at this time.
Mr. Chair, I assume I'm deferring to you as to who shall go next.
Ken, you're muted.
Ken, you're muted.
Yeah, of course I am. Ms. Jingle is next.
Yes, thank you. I was also muted. So I couldn't tell you were muted. I have a couple of quick questions, and then if I have time to come back, I will. The Trump endorsement was supposedly made on November 4th. Several times in your brief, Mr. Hewitt, it stated something along the lines of Jeremy Kauffman was not in attendance at that meeting. I understand he also did not have a vote, but that he was not in attendance. You almost touched on this in your questioning of Mr. Kauffman earlier, but then you sidestepped it. I would like to know from Mr. Kauffman if you would be so kind as to allow him to answer whether that is in fact the case, that he was not in that meeting.
Yes, I'm happy to defer to Mr. Kauffman.
Thank you.
So I apologize if Ian and I got information crossed here. I was on that meeting. I was at that meeting. I was not eligible to vote. I was appointed to the executive committee on that meeting because we had a resignation leading into that meeting. Per LPNH bylaws, members who are appointed to replace a resigning member are appointed as interim members, and for the first, I should know the number off the top of my head, something like 30 to 45 days, they are not eligible to vote. And so I did not vote on any matters in that meeting as I was not eligible to vote. And as that was my first XCOM meeting, I also did not participate in that meeting. As a secretary, I mostly took notes.
Mr. Kaufman, thank you so much for clarifying that. There have been several amicus briefs that indicate that you were there, and that was concerning to me. I appreciate your answer. The other quick question that I had.
I apologize for the misunderstanding.
No, thank you. The other question I had is for Mr. Hewitt. It's a grammatical question. There's a paragraph 13. I don't know if there's also a subcategory, but what it says is that.
I'm sorry, paragraph 13 of what document?
Your appeal.
Yes.
It's the paragraph that mentions that Mr. Kaufman was elected chair of the LPNH in March of 2026. Okay. Maybe you can find that.
Yes, I have it. Thank you.
Then in paragraph 14, it says others were elected to leadership positions at that time. And there's a specific quote, none of these officers ever supported endorsing Trump. Mr. Hewitt, is it your understanding that you wrote it in such a way that this construction intentionally meant to exclude Kaufman from the officer group that never supported
I did not
endorsing
support
Trump?
No,
sorry.
Certainly not. And
I'm
Jeremy,
a grammar nerd.
If I could clarify, since I drafted that, no, my intention was certainly not to exclude Mr. Kaufman. My position and what I was trying to kind of develop with Mr. Kaufman a moment ago is that Mr. Kaufman did personally indicate it may make sense for libertarians to support Trump, but he never advocated for LPNH to endorse Trump, and he was critical of the idea. I can personally tell my friends they should vote for Trump, and I can be against my running club endorsing Trump. And that was the distinction I was trying to draw.
Thank you. I'm just a grammar nerd. Okay. Appreciate it. That's all I have for now.
Right. I have Mr. Dixon again. But Mr. Dixon, you've spoken once. If you don't mind, I would like to hear from Ms. O'Brien first, and then we'll come back to you.
All right, thank you. Actually, I also wanted to take a second. Obviously, most of the people here know me, but for anyone watching and curious about this, I wanted to explicitly state that that I was vice chair of the Libertarian Party of New Hampshire from 2006 to 2008, and my mother is one of the founding members of LPNH, and I just want that to be like known and clear. I don't think it has any bearing on this, but I didn't want people to suddenly say that they didn't know that and that had some relevance here. So I just wanted to, for the record. So first off, I guess my first question is for Mr. Hewitt. Your petition says that the LPNH formally repudiated the endorsement. What was that process? Like, when did that happen? And yeah.
That happened subsequent to, and it's dated, so you can see this in the exhibit, but that vote happened subsequent to the disaffiliation motion. The reason for that was not that members were not hostile to the Trump endorsement prior to the disaffiliation motion. It's just that, and I attempted to kind of develop this in my questioning, there really wasn't anyone bringing up the Trump endorsement as a going concern. It was not seen within LPNH as this is something people are holding against us or associate with us, and this is something that we need to address. You heard from Mr. Weir, and you can see in his amicus brief that he was always outspokenly critical of the Trump endorsement. Mr. Hubbard, who has not only was he against LPNH endorsing Trump, he has all kinds of objections to Trump as a candidate. He was vice chair and then elected to chair. His views on Trump were well known. And so what I wanted to develop there is there was always opposition to this Bloodworth board attempt to endorse Trump, but the recognition that this was going to be sort of the leading cause for disaffiliation, that this is something some people were still going to hold against the LPNH, made everyone want to go on record. Whatever happens with this procedure, we want to be clear that we disavow this action that we never supported in the first place.
Understood. This, I'm going to ask you this question. You may want to defer it to Jeremy, but so was there any other method to denounce, disclaim, reverse, repudiate the LPNH endorsement of Donald Trump prior to the actions of the LNC? Either when Ben Weir became chair, when Jeremy became chair. Like, I understand you're saying that they didn't think it was being held against it, but there was no action whatsoever to try to give people a different impression, so to speak.
I'm happy to defer to Mr. Kaufman.
So I would be happy to start citing at least 20 tweets, probably as many as 50, where LPNH attacked Trump, denounced Trump, said that his policies and actions are bad. I know that there have been submissions of my own personal posts that have been made to the JC, and I guess, if this whole thing is arguing over tweets, we can start pulling them up and looking at them or whatever. But LPNH was absolutely unequivocal in attacking Trump a number of times throughout 2025 and 2026. And myself personally has plenty negative things to say about Trump. And so if this entire hearing is about, are you willing to say bad things about Trump? You're welcome to ask questions of me directly and how I feel about him and all of these things.
Oh, no worries. I appreciate that distinction. I'm just noting that LPNH made no official attempt to renounce its previous endorsement prior.
Okay, look, I'll be honest with you. I'm not the kind of guy who is into these resolutions and formal statements. No one reads them. People read tweets. Okay, the whereas. It's not 1980. No one cares about this crap is my sorry, I shouldn't speak that way, I guess, on an official hearing, but I just do not think that these are the types of statements that are compelling to the type of audience that we're trying to attract, because we had heard absolutely nothing from the LNC or the Libertarian Party. Again, we only got the current XCOM was only elected in March. Okay, I was the chair for a couple of months before this attack came out against us. If I knew that there was lingering concerns about something that had happened 2 years ago, I would have addressed it more promptly. In 2025, we had new elections. Every single LNC, every single LPNH executive committee member who endorsed Trump was not elected again, and there were reasons that happened. The only executive committee member who was elected again from the 2024 LNC, which endorsed Trump, was the single executive committee member who did not endorse Trump. Okay, so our body had taken care of this. We hadn't heard anything from the LNC, and so this idea that we needed to issue some formal resolution simply was not on our radar. And there's this misperception outside of New Hampshire that New Hampshire is this monolith, this thing that is like this zombie hive mind, and that could not be more incorrect. We are very divided internally with a variety of opinions about Trump and Israel and all these other things that people want to put us in a box over. And so we felt that we had fixed this in our 2025 executive committee elections when we replaced every single board member who did it.
Jeremy, if I could also add, actually, Ms. O'Brien, the best answer to your question really is the election of Nick Hubbard as chair. And I'd hope to have a few more minutes to kind of develop this with him. I mean, this is the kind of thing in an investigative committee you can go into. But Mr. Hubbard is really well known to not be a fan of Trump at all. He certainly, Mr. Hubbard identifies as on the right, but he views people on the right who support Trump, that are right libertarians supporting Trump, as sellouts, basically. He is quite hostile to Trump on a number of issues. His views were well known, and the members of LPNH elected him as chair. We only briefly touched on that in my questioning. But the main other thing I would point to is Mr. McGee has mentioned LPNH's tweets a number of times. In fact, he kind of led with that in his remarks, and the Trump endorsement was almost an afterthought. And certainly on its Twitter account, I've personally seen a number of tweets prior to this disaffiliation critical of Trump, especially on foreign policy, on the LPNH Twitter account, again, before this disaffiliation happened.
Certainly understood. Jeremy, I had a follow-up on one of the things. We've kind of danced around this question. I understand that you say that libertarians have different opinions. Did you yourself endorse Donald Trump in 2024?
I did personally endorse Donald Trump in 2024. Yes.
Understood. Thank you.
But I was also very clear that was a personal statement of mine. there are Libertarian Party officials who are live streaming this hearing, giving their own commentary, and they say, this is my own personal commentary. And the party has a ton of very clear precedent about people being able to speak as individuals versus people speaking as party officials. And I do not believe at any time as a party official I said, that we should endorse Trump.
Absolutely. I'm actually simply noting that the LPNH made a decision, you said, to elect Nick Hubbard, which could be perceived as as kind of repudiating the previous thing, but then they've also added you, who had endorsed. So it's just as viable. You know what I mean? It doesn't necessarily mean something. I just wanted that clarity. Thank you. You know what? I'm going to pass this off to somebody else because I don't know if I have other questions, and I think Pat has his hand up. Mary, Ken, I'm leaving this to you.
Yeah, I see Dr. Moulton has his hand up, and I don't believe he has spoken yet. I do have, once Dr. Moulton's done, assuming no one else new jumps in, Mr. Dixon, then Miss Jingo. So Dr. Moulton.
Okay, so you've just talked about the distinction between a personal endorsement and endorsing on behalf of the party, or speaking on behalf of the party. What I'm confused about is you seem to be making much of the fact that there has been turnover in the board, but if someone is speaking on behalf of the party, and isn't that the party's position, and doesn't the party need to be held accountable? So under your theory of agency and fiduciary duty, what prevents affiliate officers from repeatedly violating the bylaws, then immediately resigning and filling the vacancies with others in a musical chairs way to avoid accountability for what happened?
I think that the LNC look, if the LNC had acted between November, Ian's letting me talk. Now I'm going to get off the rails. But I think that if the LNC had acted, we didn't talk about this. I think the LNC had acted between November 2024 and LPNH replacing its XCOM in February or March of 2025. I would have been like, I can understand that. Like, I get completely the Libertarian Party being frustrated or finding that kind of act unconscionable, finding it a violation of the bylaws. I think that's completely legitimate. Let's also note that in 2024, LPNH was not the only affiliate to endorse a non-Libertarian Party candidate, nor are we the only affiliate in history to endorse a non-Libertarian Party candidate. So this is a very unique application of the rules where you're essentially suggesting there's no timeline. It doesn't matter what an affiliate has done to attempt to cure it. And so again, I made this comment earlier. What you're inviting is a consistent and ongoing factional battle in which any dominant faction in the Libertarian Party can purge affiliates for any action that they've taken at any point in their history. And if that's the Libertarian Party that you want, I do think it's the Libertarian Party that you will get.
I would like to add to your question, Mr. Moulton. The best answer, I think, is a letter like the letter that the McCardle LNC sent to the New Mexico affiliate saying, you are out of line, you must correct this, or you will pursue further action. And part of what I hope to develop in the limited questioning of witnesses that we did is, had that happened in this case, had the LNC sent a letter like that, there were more than enough people within the LPNH that either were opposed on principle to the Trump endorsement, or at least thought it was procedurally stupid, that those people would have carried the day, and this Bloodworth board sort of stunt of purporting to endorse Trump, that just wouldn't have reoccurred. The letter would have resolved it.
Dr. Moulton, do you have any? It looks like you're back on mute, so I'm going to assume you've completed your questioning.
Yeah, I'll come back for another round later.
Okay. Mr. Dixon.
Yes, Mr. Hewitt, I have a hypothetical.
All right.
Imagine in 2 years, the Libertarian Party has a presidential candidate, and shortly before Election Day, within days, an affiliate endorses an opposing candidate. They send out press releases and social media, hey, vote for the other person. The opposing campaign says, hey, look, the Libertarians want you to vote for us. The LNC gets wind of this. They say, we got to get control of this situation. So they schedule an LNC meeting to deal with it. They don't know what action they're going to take yet. but they schedule a meeting, and it may be the day before election day by the time they actually have the meeting. So they go into that meeting without a motion formed yet because they need to talk about it. And during that meeting, they say, we have to disaffiliate because if we don't, that affiliate still speaks for us. We need to get control of the situation. They disaffiliate. They follow 5-6. And then they send the national party sends out press releases and so forth, try to get control of the message to the extent the media covers this at all. Are you arguing in that case that cannot stand because there was not notice?
I'm arguing that that would be an excellent case for disaffiliation of the affiliate for cause, and that the affiliate would be owed whatever process the LNC secretary would be owed if the LNC secretary has said, I'm LNC secretary and I endorse Trump. And the board wanted to proceed against the secretary to remove the secretary as an officer. There would still be a for cause requirement. Perhaps there's a way to fit a for cause proceeding into a 48-hour timetable, but the for cause requirement in Robert's rules would apply. And that would be a basically procedural requirement of some sort of notice, investigation, and finding. And we know that because if you control F for cause in Roberts, every single time it comes up, 5630, 2616, 63-1, it's always about this basic procedural fairness of notice, opportunity to respond, investigation, findings. Maybe they could have done it quickly, but they need to do it.
So it sounds like you're saying that the for cause means there must be notice. Is that right?
For cause requires notice. And if you don't want to look at Robert's rules, by the way, that's in the Libertarian Party bylaws.
Oh, okay. So when you say for notice, what would be perceived as valid notice if they tried to make a phone call or send a text message? There's no confirmation that anyone receives it. Is that notice?
Well, if someone doesn't need to receive notice for it to be notice, I mean, that's a pretty, let's assume there's a good faith attempt to in fact notify them. At that point, I think it's for this committee to decide whether.
So if there's evidence that, hey, we tried to contact you, that's good enough?
About this specific thing, not some totally unrelated thing several months ago.
In the hypothetical I gave, it would stand if somebody's in the meeting and they say, we got to pass a disaffiliation motion, send an email right now. We sent it. Okay, let's vote. We don't need to worry that they got it yet. Is that right?
No, that wouldn't be notice. If you sent an email and then went into the meeting and voted, I can't imagine how that would be good faith attempt to notify them. They would have
that would not be good faith. That's not good enough.
If you were engineering the timeline so that they had no opportunity to respond, no, that wouldn't be notice.
So really, in that case, the LNC couldn't do anything, right?
They would be precisely as handicapped as they would be if an LNC officer endorsed Trump and need to be removed for cause. Same limitations would apply. Now, perhaps you could temporarily disavow the affiliate or temporarily suspend the officer. You can suspend maybe their ability to engage in wrongdoing while you're doing the for cause investigation. But if the bylaws require for cause, the bylaws incorporate Roberts. Roberts defines for cause as you've got to at least check these basic boxes procedurally. Then absent an amendment of the bylaws, that's the procedure that's owed. The bylaws is a contract.
Okay, before I pass the baton, I just want to understand here that if the LNC follows 5-6, that is the procedure for disaffiliation, correct? There's not a
yes, bylaws article 5-6.
You go to 5-6.
Yep.
Now, you seem to be suggesting there's a hole in 5-6 because 5-6 does not say you're not excluded from having to give notice. So there's a hole in 5-6 and you need to go to Roberts. Is that right?
No, notice is right there in 5-6.
No, okay. I'm looking at 5-6. You're saying in 5-6 it says notice has to be given?
A motion to revoke the status of an affiliate party for cause must specify the nature of the cause for revocation.
Oh, right. You're using cause and you're saying that is notice, but it doesn't explicitly say notice, and you're using cause as defined under Roberts, right?
Well, it depends, by the way, on what part of the motion we're talking about here. If we're talking about these social media posts, then even if you think this JC hearing is sufficient notice, nothing in the motion specified the cause for revocation when the motion says bad social media conduct. There's no possible way that the burden of proof can lie on the appellant there. But the basic construct for cause is a Roberts Rules construct. The bylaws incorporate Roberts Rules, and Roberts Rules very extensively throughout 61 through 63. It discusses for cause as these basic elements of procedural fairness. And it even says if you lack definite procedures as to what the disciplinary procedure is, default to these basic elements.
All right, so cause and nature of cause, it's not sufficient to say they violated 5.4 of the bylaws. If they say you violated 5.4 of the bylaws, that's the cause and the nature of the cause. You're saying no, it isn't.
So the line says that a motion to revoke the status of an affiliate party for cause must specify the nature of the cause for revocation. So there's two clauses in that sentence. The second clause is the motion to disaffiliate for cause must specify the nature of the cause for revocation. That second clause is dispositive on this social media thing. Then there's the first clause of the sentence, which is the motion is to disaffiliate for cause. And then earlier in 5.6, it says that the LNC has the power to disaffiliate an affiliate for cause. What for cause means, and this committee said this in Philly's case. I know this committee takes the position precedent isn't binding, but it's been done before. It said that where you use this term for cause, you have imported the Roberts Rules concept of for cause. And Roberts Rules has an extensive concept of for cause that is some kind of notice, some kind of investigation and findings. So my answer differs depending on which clause of that sentence you're talking about.
I'm gonna pause this right here. We're technically at time. Mr. Neal has not had an opportunity to speak. I don't know if he wants to or not. Ms. Jingle wanted to speak again. It looks like Pat would like to speak again as well.
I'll move for a 10-minute extension if that's what you need.
Well, I'd like to go 15.
Okay, I accept that amendment.
Oh, and that's right. Dr. Moulton also wanted to speak again. I see his hand up as well. So here's what I'd like to do if we can. Mr. Neal, do you have any questions that you would like to ask? You have not had a first bite at the apple. Are there any questions that you would like to ask at this time?
Not at this time, to be honest with you.
Okay, that's no problem. I'm just trying to make sure everybody at least has one bite at the apple.
Oh, my hand would be up if I thought you were ignoring me.
No.
How about you, Ken?
I'm pretty satisfied with your all's questions right now. So I'm okay. Mr. Dixon was in the middle of I don't know how much further he had to go to finish his line.
I think 2 minutes.
Okay. And then Ms. Jingle wanted to speak, and Dr. Moulton wants to speak.
So let me try this. Close this up, Mr. Hewitt.
Real quick, hold on. Let me do this. If there's no
I'm sorry, we didn't extend.
So if there's no objection, we're going to hear Mr. Dixon wrap up his within 2 or 3 minutes. We're going to hear Ms. Jingle for no more than 10.
No, that's
hopefully it's less than that.
Yeah.
And then Dr. Moulton for no more than 10. Hopefully it's less than that. And then we're going to call this section done. And I'm going to go down to the bar and get a drink. I'm joking, but the point is that we will call this section done at that time. Is there an objection to that?
I'll probably may extend, but anyway.
All right. Well, let's start here. Is there objection to this procedure right now? All right, Mr. Dixon, go ahead and finish up if you can within 2 to 3 minutes.
All right. So where I want to close this out, Mr. Hewitt, is you're relying heavily on Chapter 20 of Roberts. That's 61 to 63. That's discipline of members and guests. And my interpretation of that entire section has to be discipline of individuals such as officers of an organization. You seem to be saying that an affiliate is a member and that disaffiliation is disciplinary. The dictionary definition of discipline, as I understand it, is to modify behavior. If a child's misbehaving, a smack on the bottom or a timeout will prevent that, but breaking that bond, no longer connecting, is that actually a disciplinary? So I'm asking you to, where would we point to say Chapter 20 actually applies in this case for affiliates and discipline?
Well, I don't see how it couldn't be disciplinary, because clearly the removal of an officer is disciplinary. That I think that's unambiguously clear in the bylaws. It's unambiguously clear in Robert's rules, which is incorporated into the bylaws. And removing someone or expelling a member, which is also disciplinary, that requires this basic for cause process. That's also severing the connection. I think you raise an interesting question as to whether an affiliate is a member. I could see arguments on both sides for whether an affiliate is a member or not. But in any case, 5.6 says affiliates are disaffiliated for cause. And so it just so happens that Robert's Rules has this extensive 61 through 63 section on what for cause is. If you control F for cause, it's always got these basic procedural elements. And there are all these principles in Robert's Rules that are part of the bylaws that tell us how we interpret a provision like this. You interpret it in harmony with other provisions of the bylaws. The principles underlying Robert's Rules section says subgroups have the right to be heard. That's recognizing some sort of group, not just individuals. There's a preference against instability, and you're supposed to avoid absurd interpretations with the bylaws. So part of what I'm arguing, a central part, is that the concept of for cause in 5.6 should be the same for cause as we actually really all agree, even the LNC and Mr. McGee agree, for cause in the officer removal context involves at least some minimal elements of process. That's also a legal definition of for cause.
All right, Mr. Dixon, if you don't mind, we'll go to Ms. Jingle next. Ms. Jingle, go ahead.
Okay. So I'm going to address this to Mr. Hewitt. I'd be thrilled if you want to toss it to Mr. Kaufman. And I understand your legal skepticism, or I sort of understand your legal skepticism about social media as something that we should be judging. But in a number of amicus briefs, there have been numerous mentions of Mr. Kaufman posting inflammatory and anti-quote statement of principle comments on social media. Some specifically espousing violence against elected officials and other public figures. My question is this: were any of these posts official approved LPNH posts? And if so, what was the thinking of the LPNH Executive Committee about these posts?
I'm sorry, could I clarify before I defer to Mr. Kaufman? Are you asking about tweets made from Mr. Kaufman's personal account or from the LPNH?
I don't know, because people were referencing these things. There were a number of mentions in the amicus briefs. The question could be reconstrued to say, did Mr. Kaufman ever post official things espousing violence against either elected officials or other public figures? And if so, if they were official, what was the thinking of the LPNH Executive Committee about those posts? Were they approved? Did they discuss it, etc.?
Well, I will defer that to Mr. Kaufman, but I'd be remiss if I didn't point out there are, as you pointed out, there are many different tweets in many different amici, and it makes it hard to know what tweet specifically we're talking about. And this is precisely why it's so important that even throw out Robert's Rules 5.6 just on its face. The bylaws say with specificity, spell out the cause for revocation. And so I would ask, if there was some violation of some agreement even, why not at least mention one tweet in the LNC meeting? Why not have one tweet in the letter, and we could then discuss specifically that tweet? I'll defer to Mr. Kaufman, but there's no possible way we could have had any sort of notice and put on any sort of defense about a specific tweet unless we knew what that tweet was. But I'm happy to turn that question over to Mr. Kaufman.
So let me just follow up for a minute here. I believe Mr. Kaufman knows the tweets I'm talking about, and I'd be happy to hear his response.
Mr. Kaufman, I defer to you.
Well, I would start by echoing Ian's answer, because that's exactly what I was going to say. This is why you need an official procedure. It is, again, I've been investigated by the federal government. I spent 5 years of my life fighting a civil case against the federal government because I kept unpopular content on the internet for tens of millions of people during COVID. Pretty libertarian act, I would say. The procedure there involved an actual investigation. It involved actual fact finding. It involved actual discovery. So the fact that it's defend an ambiguous cloud of tweets, what is going on? You guys are supposed to be better than the federal government, not worse. If we're trying to rally people to our side, then we ought to be showing that we govern ourselves better than the federal government governs us. This is not that. If you would like to read out any specific tweets that you found objectionable or anti-libertarian, I'm happy to go through them one by one. I care a lot about the Libertarian Party in New Hampshire. I'll stay on this call for the next 6 hours. We can have a full cancel session, and you can read every tweet off one by one, and I will tell you why I think they're libertarian or why I said them. I'm not interested in defending an ambiguous cloud of tweets. I would instead pose to you, why do you think the Second Amendment is useful? Why is that necessary to defend our liberties if there is under no scenario a gun can be fired?
No, I see. And I'm not the one that's answering questions here, so I'm not going to answer that.
It's something for you to think about.
But I appreciate your point. I appreciate your point. I guess let me boil down my question to this. Did the LPNH Executive Committee approve any posts that you made that called for, say, if somebody kills Kamala Harris, that will be fine, etc.? There were several, and it could be that those were your personal tweets. I'm totally happy to hear that as the answer, but I just want to know if the LPNH had anything to do with them.
Sure, I'll offer you a couple of follow-up statements and information that might be helpful here. So one, in general, if LPNH has deleted a tweet, that's an implication that we don't stand by it. Now, it's not necessarily true that every tweet we have not deleted, we stand by today, because it's difficult to go back and go through every tweet. But if there's a tweet that you're concerned about, look it up. If it's been deleted, that is an unambiguous statement by the Libertarian Party of New Hampshire under my leadership that I don't stand by those tweets. And I have already deleted a number of past posts that I do not think are appropriate for the Libertarian Party of New Hampshire to make. Okay, and again, that's not saying that there aren't some we missed. A lot of tweets have been made over the last 5 years. I haven't read them all. Second, as someone who has led teams of individualistic, bright, creative men and women, you will not get good work out of them if everything that they want to do requires a committee to approve it. Committees are where creativity goes to die. So under my leadership, the policy has been people are free to take shots. People are free to make mistakes sometimes. And we have made mistakes. I'm not here to defend every tweet we've ever made. I think we've made a number of mistakes. Okay. I think we have posted things that aren't correct. We've clearly posted a lot of things that are correct. There's a reason the Libertarian Party of New Hampshire has over 100,000 followers on X, a state of 1 million people, yet we have something like 70 or 80,000 more followers than the next largest state. We have large teams of people who want to post and create on this account because of our procedures and the types of people who participate here. You can ask your favorite LLM, however you do research, what's the most successful Libertarian state affiliate on social media? They'll tell you the Libertarian Party of New Hampshire. So what we've done has been successful. Have we made mistakes? We absolutely have. I'm not here to defend everything we've done. So I'm sure we've made mistakes, but I do not think the solution to human creativity is to channel it through a committee. I think that's a tremendous mistake.
All right, Ms. Jingle, if you don't mind, Dr. Moulton was up next, and then I see Ms. O'Brien has also raised her
I think Avin suggested that she had a follow-up to that, but
Ms. O'Brien, do you have a follow-up that's directly related to what Ms. Jingle has asked?
Yes, it was a question inspired by one of Jeremy's answers just now, as I wanted to ask Jeremy, has the tweet endorsing LPNH endorsing Donald Trump been removed from Twitter?
I'm happy to let Jeremy answer that question.
I'm actually checking right now.
I thought that's what you were doing.
I'm going to tell you right now, if it hasn't been, I'm going to delete it live on this call, okay? Because that's not something we stand by.
As of 2 hours ago, it was still up. So
okay.
just clarifying.
I'm going to tell you, it's going to go down right now.
I can tell Ms. Janelle thinks I'm perhaps throwing my client under the bus, so I should add that, I mean, at this point, I don't see how LPNH's position can be any clearer. LPNH did publicly post a statement saying this was completely inappropriate and repudiated it for very specific reasons already.
Actually, follow up on that, Ian. Sorry,
I didn't ask that question. Yeah.
So as you said, they made a public statement. I mean, I saw the petition and it had that statement. I know that when the tweet endorsing Donald Trump came out, that was a tweet about a resolution that the LPNH made. Was there a tweet regarding the repudiation? I know that maybe that doesn't make good social media content,
but yes, we did.
There was.
And you're correct, Evans. It doesn't get any attention because it's not a good play on social media, but we did.
Did you use any fun language? Because you use very colorful language. Did you go oh, we fucked up, and did you do anything interesting to make people pay attention to it?
But we weren't trying to bury it. We didn't. This isn't something we buried. Look, again, I didn't do this, and we can have our disagreements, but I actually feel very strongly in following the rules of the groups that I am a part of. I think that is a sincere and important part of being a libertarian, that you respect the rules on other people's property, that you respect the rule when I go into, when I go into a restaurant, I follow their rules. Okay, everyone is in control of their own private property and they get to set the rules for those things. Okay, and I understand that the Libertarian Party of New Hampshire, that is a voluntary relationship with the Libertarian National Party, and it is not our ability to do whatever we want. That is not our relationship. I understand that quite clearly. And I'm happy, again, I've been chair since March. I have not been in charge of the Libertarian Party of New Hampshire for most of these actions. I've been in charge of the Libertarian Party of New Hampshire for 6 months. It's not even 6 months. I can't do math. It's 5 months. And for the last 3 months, this whole battle has been going on. At no point did I get any requests. At no point did I get any of this feedback. Okay? What happened was, 3 minutes after the new LNC was elected, the LNC came at us in a way that was clearly premeditated, clearly plotted, in a way that wasn't even made public. It was not being publicly discussed that this is what the JC members were running on, or this is what the LNC members were running on. Quite frankly, I think the voting results would have been different if people had made these positions clear. This was something that was kept secret, that was then chosen to be executed on immediately, without notice, without due process. And we're supposed to be better. That's the whole point. If you want people to follow you, you have to be better. You have to be someone that they look up to and respect. Libertarians sometimes think it's about philosophical arguments. They're not going to care about your philosophical argument if you're a fat loser with Cheeto dust on your shirt. You have to be someone that people want to listen to and want to follow, and they do that by seeing who you are and how you conduct yourself and how you behave. And I know some people might not like how I conduct myself and how I behave, but there are a lot of people who are clearly attracted to it because I don't back down. I don't apologize if I think I'm right. And I bring facts and evidence, and I go very hard. And there's people who like that. There's people who like the way that LPNH conducts themselves. And for people who are supposed to understand concepts of revealed preference, it'd be nice if you could apply them in this matter.
All right. I'm going to move to Dr. Moulton, and then unless there's a motion to extend, I see Mr. Dixon's hand. I assume that's going to be a motion to extend. Let's hear from Dr. Moulton, and then I'll hear your motion, Mr. Dixon.
Thank you. I wanted to ask a bit about cause. So there seems to be two causes that were alleged. One was endorsing a Republican nominated candidate over a Libertarian nominated candidate, and the other was repeatedly posting statements to social media that directly contradict the statement of principles. So what I've heard throughout this hearing is collateral attacks on both of them, talking about notice or an investigatory committee, or that it wasn't a valid endorsement under the LPNH bylaws, or that there's different people on the board, or in the case of the social media statements, that they were not stated with specificity, listing which statements were problematic. So I just want to directly ask, hypothetically, if the LNC had an had an investigatory committee, followed all the process that you wanted. It was the same people on the board. It was a valid endorsement under LPNH bylaws. Do you agree that a Republican endorsing a Republican nominated candidate over a Libertarian nominated candidate would be valid cause under the bylaws? And do you agree that repeatedly posting statements that are directly contradict the statement of principles would be valid cause under the bylaws if they were stated with specificity? And that's for Mr. Hewitt.
Well, the second part of your question is very easy, which is absolutely not. I mean, that statement is just, you're doing bad things. If there's one kind of statement that can't possibly be a specific for cause allegation, I would say it's that kind of statement, repeatedly doing bad things. It needs to be specified even to meet bylaws 5.6. But to the first part of your question, my answer is a little bit more nuanced there. I would say the bylaws require that the action be for cause. For cause is defined in Roberts, among other places, to involve some sort of elementary process, especially, by the way, 63.7. If you're going to look at one place in Roberts, I would say look at 63:7, because there they say that the default period is you need to have some sort of fair disciplinary process with these elements to oppose a disciplinary sanction. And then that's contained within this larger discussion of what for cause is. So theoretically, you can imagine a for cause process and disaffiliation against an affiliate who had endorsed another party's candidate. But I happen to think that if the LNC had followed that process, and this I think is probably part of why this didn't happen, if there had been an investigatory committee, that investigatory committee would have gone into all the details I just tried to develop in that brief 20 minutes of questioning, but in much more detail, and it would have seen this Bloodworth board vote thing was a silly stunt. This did not have the support of the members of LPNH.
Again, you're talking about collateral attacks on this by talking about procedure.
But it's not collateral because it's part of what for cause is.
Would that be a valid cause, endorsing a Republican over a Libertarian? Under the bylaws, is that a valid cause if it happened? You're disagreeing whether it happened. If it did happen, would that be a valid cause?
You could disaffiliate an affiliate through a for cause process for endorsing another candidate. I just think if you had that for cause
secondly,
process,
could you disaffiliate on a for cause basis for making statements that contradict the statement of principles if they were stated with specificity? Which statements? If you had an investigatory committee, that type of thing, like taking out the procedural collateral attacks. Do you concede that that is a valid cause for disaffiliation?
It is not a collateral attack because it's part of the essence of what for cause is. It's throughout 61 through 63. But no, the reason I can't concede that is there's no specific statement. And that's precisely the problem with having a generic statement that you are bad and say bad things and trying to have that be
isn't the purpose of specificity and notice that letting people know what they need to defend against? And weren't you given that notice when LPNH was censured 8 months before that, when people repeatedly complained to LPNH? And these weren't private statements. These were all public statements LPNH put out for everyone to read. So why are you acting like you didn't know what the statements were?
It's a moot point because Article 5.6 of the bylaws says just on its face, the motion for disaffiliation needs to contain the notice we're talking about here. It needs to state with specificity the cause of disaffiliation for cause. So even if this September 2025 censure had been some sort of notice, it wouldn't comply with the bylaws, to say nothing of Robert's rules, to say nothing of what for cause means in the case law.
Thank you.
All right, Mr. Dixon, I know you wanted to, I believe, make a motion. I guess the real question is does anyone else want to speak other than Mr. Dixon after this? Because if so, we can just let Mr. Dixon go. I'm not hearing anybody else say anything.
I do have one other follow-up question. It's a brief one, so I could go after Mr. Dixon right now.
Is it related to what you were just talking about?
It's related to what earlier people were talking about.
Okay, then we're gonna hear from Mr. Dixon, then Dr. Moulton, and then without any other motions, we're gonna wrap this section up. So go ahead, Mr. Dixon.
Thank you very much. I may actually have more questions, but I'm going to do this the right way. So, Mr. Hewitt, a lot of your brief referred to the so-called Dixon Committee, and I have to admit, when I first saw that, I said, what the heck is a Dixon Committee? I started doing Google searches trying to figure out what a Dixon Committee is until I found, oh, that was my committee. So that committee, you're
So that's Earl
referring,
Warren.
I guess I'm famous or something, but so that committee that I was chair of, when you reference it, you're saying that established a precedent, and the motion that enabled that committee said it was for internal issues not covered by the Judicial Committee bylaws and policy manual. When we have 5.6, wouldn't that say that 5.6 is in the bylaws, so the so-called Dixon Committee doesn't apply to that?
It said we were establishing a precedent for the internal affairs of affiliates not covered by the bylaws, JC rules, etc. So
right, but the 5.6 is in the bylaws, and that's what the LNC used. So are you saying that in order to do it the right way, you had to use a so-called Dixon Committee, or could it be any investigation, even if it didn't follow the so-called Dixon Committee model?
well, yeah, I mean, it's kind of 6 of one, half a dozen of the other. So, one separate argument is there was this motion creating what's been called by us and some amici the Dixon Committee, and that created an expectation if you're intervening in an affiliate's internal affairs, you're going to follow some sort of elementary process. Then separately, there's, I pointed particularly to 63:7. I think that's actually the most on point Robert's Rules provision to your question, because it says not every society needs to articulate in great detail what your disciplinary process is, but it's at least got to follow some of these basic elements. Notice where you can respond, some kind of investigation or trial, and some findings. So, at minimum, this would be a much different case if there, and I wouldn't have been able to say 90% of what I just said, if there'd been at least some kind of elementary pursuant to 63:7 notice, you can show up, we're going to cross-examine witnesses, we're going to do some kind of report, even if it hadn't followed exhaustively what we're calling the Dixon Committee model.
Well, imagine, just for the sake of argument, the LNC motion just was the Trump endorsement. That's it. They didn't mention the tweets and other things. So it was just the Trump endorsement. Wouldn't an investigation just say what you've already admitted in your brief? It's proven. What investigation would there be? Why would there need to be an investigation?
Are you investigating Colorado?
Because
I'm asking Mr. Hewitt.
Because Article 5.6 says you can only do this for cause. So, I mean, you can say, well, in principle, shouldn't we be able to kick them out if they posted something that we think is in violation of the bylaws? But that's not what 5.6 says. It says you can only do it for cause. For cause entails some sort of rudimentary process in every source. So the LNC doesn't even have the power to do it unless it is for cause, which means following this process. And yeah, I gave a couple of examples of why I think the outcome would have been different. If there'd been some sort of process, they would have seen it doesn't really make sense for fundamental fairness reasons to disaffiliate this chapter. Most people aren't on board with this. And one thing I mentioned is they would have seen the board members who did this didn't even have the authority to do this. This was just an ultra vires silly virtue signaling stunt by some board members that was completely outside of line.
What I want to clarify is if the LNC said, let's appoint Pat Dixon again and have his 3 people do an investigation, and we said, we're done. We know it took 5 minutes. Here's your report. Would that satisfy you?
If it was similar to the Dixon Committee process, then the LNC would be discharging its obligations. It would be for cause.
All right. I'll move on. I'll pass the baton.
I'm seeing that Mr. Neal has his hand up. He has not spoken yet.
Yeah, I'll be very quick. I know I already am, but I will. All right, so the New Hampshire Executive Committee meeting where a vote was taken, an endorsement of Donald Trump passed by that body. Is that in written minutes?
Yes. I believe
Why
that
do
we
you need a
included them in
committee to read official record of an executive committee?
I'm
Seriously,
sorry.
why?
Could you repeat that again?
Why do you need an investigative committee to read the minutes of an executive committee? To me, that's sufficient evidence and that is cause.
Because you don't have the legal power to do it otherwise. The bylaws give the LNC the power to disaffiliate for cause. Every single source for cause involves some process. Throughout Robert's rules, in this committee's other cases, in the case law, for cause means some elementary process. Whether you think it makes sense to disaffiliate or not, they can't do it except in the manner prescribed by the bylaws, which are a contract.
Oh, yeah. Okay. So, Mr. Neal, you satisfied there? You're done with your questioning? Okay. Dr. Moulton, you were up next, and I think
Yeah.
Mr. Dixon would like one more bite at the apple after
Sure.
Dr. Moulton.
I'm going to be really brief. This is a factual question for Mr. Kaufman. You mentioned that several problematic tweets were deleted. Could you let us know the timeline? When were these tweets deleted? Were these tweets deleted after the vote to disaffiliate, or were these tweets that were problematic, were they deleted like a long time ago? When did these deletes happen?
Mr. Kaufman.
LPNH has probably deleted 20, 50 plus tweets over the years. You guys haven't even seen all of our bad tweets. There's bad tweets you don't even know about. There's secret bad tweets that no one's ever seen. I think you're misunderstanding. Look, I'm being straightforward. The way that we do things, and I explained it earlier, we encourage people to take shots. Creative and capable people will not thrive under committees. I have an entire anti-committee. I don't even believe in the concept of committee. There should be one single person owning everything. There should always be a single individual responsible. That individual may choose to use a team. They may choose to work with others. But the idea that a bunch of people would have equal status to decide things, nothing great, nothing even good has ever been created via these procedures. These are the procedures where good things go to die. So that is not how we do things. That's not how things work. And our methods work. And again, there's this myth that I make most of the tweets. I've made less than 25% of the tweets that LPNH has made over the last 5 years. Probably even lower than that. A variety of people make the tweets. Sometimes people make mistakes and we talk about them. And if a mistake was made, we correct it. That might be a tweet that only got 30 likes. That might be a tweet that got 10,000 likes. Okay? We've deleted a variety of tweets. I actually instituted a procedure called Tweet Court, where people can pay money to cause an argument about tweets. But capable people will not do work when there are 50 people backbiting them and judging them and criticizing them for every mistake. Not that many people will stand up and go through procedures like this. There's a reason that the LP has driven away so many capable and creative people, and why you're stuck with the kinds of people who put their finger in the air and will only make a decision if enough people agree with them, and why you're devoid of talent to a substantial degree. And it's because
all right, I think that's quite enough, Mr. Kaufman. We don't need to listen to your criticism of the Libertarian Party. That is not part of this procedure. And I would ask you to behave yourself and to be quiet, or I'll ask the chair to mute you permanently.
Well, you should listen to people who know more than you about social media. I'm better at social media. Stop. You guys should be asking questions on how to do things better, and I could teach you.
Ken, turn him off, please.
Hang on. There's an objection to continuing to hear. It sounds like this is tangented into something else beyond the answer. There's objection to hearing anything further down that tangent. Is there objection to ending the tangent from the committee? I'm not seeing any. All right. We're going to hear from, okay, Dr. Moulton was speaking. Dr. Moulton, are you done with your questioning?
I'm finished. Thank you.
Thank you. Sorry, I'm from Kentucky. I used done and finished wrong. And Mr. Dixon,
thank you. I think I only have two more, so hang in there. We'll have a break after this. So, Mr. Hewitt, in at least two of the Mickey roots and ruse, they make this argument about compound motions, and the concern that there was not individual 3/4 votes on each of, I'm going to call them causes, but each of the causes. Are you concurring with that interpretation?
I've read most of the amici. I'm not in a position to comment one way or another on those particular briefs.
Okay. Let me put it this way. If I say I want to disaffiliate them because they endorsed another candidate and because it's raining and my baseball team lost, do the other two things that are obviously not germane taint the entire motion, or is it sufficient just to say one of them is clearly a cause?
It's an interesting question. I did read all of the relevant Roberts, or most of the relevant Roberts Rules provisions, but I did not read the provisions on compound motion, so I am not in a position to answer your question.
Okay, very good. Here's my last question. In quite a few of the amici, including your brief, there's reference to case law. In your brief, for example, Campbell v. Lowe's Incorporated, which is a Delaware state case, as I understand it. And the National Party is not a Delaware corporation. If it's governed by anything, I assume it's the DC circuit or something. So my question is, when we make our ruling, should we really care about these cases external to our own rules?
You should, because the bylaws are a contract. So the terms in the contract do have legal meaning. And for cause has a normal legal meaning. You can, we cited some cases as examples that are sort of cases that are commonly cited in the case law, but for cause has a pretty similar legal meaning if you look at it in the corporate governance context and other cases as well. You should consider, there was the attempted amicus briefs from various affiliates mentioned this concept of promissory estoppel. When you induce reliance on a certain procedure, you can sort of be held to it. Even if, this committee doesn't see itself as, having the job of applying the case law, the bylaws are still a contract, and the contract, its meaning still comes from the way the legal system operates.
Right. But for example, just in the case of Campbell v. Lowe's, my understanding is that's the state of Delaware. Is there something that is binding from a case in the state of Delaware on the Libertarian Party?
We cited the cases that we cited not to suggest that these particular cases are binding on the LNC, but just to give examples of the sorts of ways legal terms of art like for cause are used in the case law.
Should we be concerned that whatever our ruling is, if there's subsequent lawsuit, that we should make ourselves airtight against that case law? Because then we're kind of opening ourselves up to the universe.
Look, you want to. Obviously, I can't legally advise the Libertarian Party, but any person who's anticipating possible litigation, of course, wants to know first and foremost the way terms are used by the courts of the relevant jurisdiction, the jurisdiction where you anticipate doing litigation. But nonetheless, it's very common, don't take my word for this, talk to other civil litigators. When there are kind of common terms of art like this, you're not going to see, for example, a trial court in Florida say, oh, I'm only going to look at the Florida case law to determine what this term means. If there's a big constellation out there of cases that define a certain term a certain way, you're probably going to see that definition be authoritative.
Thank you very much for your answers. I very much appreciate your responses.
Thank you.
All right. Committee members, we are well over time. I'm going to look and see what time we started this. Looks like it was 9:09. It is now 10:16, so we've run an hour and 7 minutes.
But we did add a half an hour, Ken.
That was after the half hour we added. We started Q&A at 9:09. I have it written down to keep track. So it's been an hour and 7 minutes. We're definitely taking a break right now. My hand hurts a lot because I've taken lots of notes. I would like to suggest how about what time is it? How about we come back at 10:25? So it's a 9 or 8.5 minute break. That's a nice even time for me to start. We will start at 25 on the dot. So please don't be late. In fairness, we will give the LNC and the questioning up to 1 hour and 7 minutes if we need it, just to make it all nice and fair. So just to set everyone's expectations, that's going to put us at 10, 11, 24 before we get to the 5 minute closings that we have scheduled. So, and as some of you know, it is my opinion that because this is day 40, we are not allowed to run past the stroke of midnight. So let's not. So, with that said, let's go to break for the next 7.5 minutes or so, and then come back here at 10:25 p.m. Eastern time. And don't forget to mute and turn your video off, because don't get caught on camera doing something silly. Sorry, I was making coffee. This is the less than 1 minute warning, if I'm reading my clock right. Yes, less than 1 minute warning. I had to make coffee. It is now 10:25 p.m. Eastern Time. We're back. And it is time to do Q&A with the respondent, the LNC, through Mr. McGee, their representative. And hands are going up. I saw Dr. Moulton first, and then Mr. Dixon, and I thought I saw Miss Jingle, but then she seems to, oh, no, she's there. Okay, something moved. So, so I have Dr. Moulton, then Mr. Dixon, and then we can queue up after that. Mr. McGee, are you ready to go?
I am.
Excellent, sir. All right, so we're starting here at 10:25, and go ahead, Dr. Moulton.
Okay. I am gonna focus in on, I think, the best arguments for LPNH, because I think most of the procedural stuff is complete bullshit. But I have three specific questions for Mr. McGee. First of all, are there any time limits on endorsements constituted in cause for disaffiliation? So I'm going to give you a hypothetical. Suppose under state law, the Libertarian Party of Texas can't block a candidate from the ballot if they pay a filing fee or collect thousands of signatures. If the Libertarian Party of Texas publicly endorsed Ron Paul for Congress over a Libertarian that made the ballot under state law, back in 2010, long time ago, could the LNC disaffiliate the Libertarian Party of Texas right here, right now, for an act done 10 years ago? And if it can't, what is the line? How long do they have to actually disaffiliate after some bad action?
Well, hypothetically, yes. Certainly, I think certain consideration should be given to a 10-year gap, especially if there's other underlying evidence that could potentially mitigate that. However, obviously, that's not the case at hand.
Okay, my second question. In your brief, you said calls for political violence violated the statement of principles, citing specifically Libertarian Party of New Hampshire's calls to violence against State Representative David Muse and President Donald Trump on social media. This was in your brief, not in the original motion that was passed by the LNC. Does this still constitute valid cause when the National Committee itself is also calling for political violence, as with the guillotine tweet from a few weeks ago?
First of all, I did not see the national comms do any such thing. If they did, shame on them. But it would still constitute valid cause.
Thank you. My third question, why didn't the LNC include specific tweets in its second count about violations of the statement of principles?
I actually cannot answer that because I was not the one that drafted the motion.
That's all the questions I have. Thank you.
Okay.
Oh, I'm sorry. Could I ask, since there are witnesses here, did you want to defer that question to anyone else present, or do you think no one can answer that question?
I mean, if Mr. Nikela has any additional information about that, he can take a crack at that, but otherwise, no.
Okay, thank you. No more questions from me.
All right. Mr. Dixon.
Thank you. Mr. McGee, one of the items I'm wrestling with in your brief and several of the amici is the notion that disaffiliation is a de facto motion to rescind. And in your brief, you seem to suggest that a 2/3 would have been allowable, even though in 5-6 it requires 3/4. And it's not clear to why you're even bringing this up. How are we supposed to interpret this idea that it's really a de facto motion to rescind? Why is that pertinent?
Well, it's pertinent because because it would be a lower threshold, and because it's a different threshold than other procedures found elsewhere in the bylaws, such as Articles 6.7 and 7.5 for at-large and officer removal, and 14.5, I believe, for recall of presidential and vice presidential candidates.
Well, all right,
And
but
so,
are you suggesting that it really is not 3/4 as in 5-6?
no. The point of bringing that up was to state, was really just to say that we cleared it, the LNC cleared any vote threshold short of 7/8.
Okay, but I'm not. It doesn't seem to add anything to your argument, and that's why I'm asking about it. If you hadn't even put that in the brief, are we missing something? 5-6 says 3/4. I don't know. I don't understand the motivation for that interpretation.
It was just used as a comparison, and certainly if you remove it, the argument doesn't fall.
Okay. All right. I'll pass the baton and ask for it back later.
All right. Next up, I see Mr. Neal, followed by Mr. Goldstein.
Okay, I had the opportunity a few days ago, maybe a week ago, to talk with a member of the LNC the last term. And I said, why wasn't New Hampshire disaffiliated last term? And he said, because the votes weren't there. Now, what I'd like is if somebody else who is on that committee can say whether that is an accurate statement or not. Because, I mean, some people I know have said, well, geez, you're taking action now and it's almost 2 years after the fact. Why didn't you do it more timely? And that would be, in my opinion, one explanation why. So I know Mr. Nikela was on there. I don't know if anybody else here was on that committee. Somebody care to speak to that?
Certainly, if Mr. Nikela or Mr. Bowler, who were both on that previous committee, want to speak to that, they can.
The question is whether the conversation, if there was a conversation about votes not being there, on whether or not to pursue this. I don't remember having that conversation, but I do know I did have conversations with colleagues that had disdain over the fact that LPNH had endorsed Donald Trump. So I can't speak to any motivations behind why somebody would or wouldn't take action at that time.
And Mr. Buller, I didn't know if you were going to jump in there as well, but you were muted. So
yeah, I can jump in. So I didn't join the committee until I believe it was August of 2025. The censure motion was in September, and shortly after that, the censure motion didn't seem to have an effect. So we had actually started the process of documenting everything for a motion to disaffiliate, which we had planned on bringing at the November meeting of 2025, but we didn't have one. And there was talk that it would be better to do it at the in-person in December, since it's such a big issue, a big thing to do. And then once it was too late, we found out that we couldn't do any type of motion to disaffiliate within 6 months of the convention. And so we wouldn't be able to move it back in December. So had it not been for those things, we would have tried to move on that around November of 2025.
So it's fair to say then that there was consideration of doing an affiliation prior to the first LNC meeting of the current term. This wasn't somehow an imported conspiracy that came up after the fact, after the convention.
Correct. I spoke
Thank
to several other LNC members and started trying to get co-sponsors in case we wanted to do it by email ballot, but the consensus was that would not be the best way to go about it.
Mr. Neal, are you satisfied then with your questioning being completed? Mr. Neal, you're good?
You're muted, Jeff.
I'm sorry, my hand's down and I'm all done. I'm done. That's it.
All right, just making sure. Mr. Goldstein and then Ms. O'Brien.
Okay, I would like to ask Mr. McGee if he would defer to the national chair who's on this call, and if the national chair is willing to answer a couple questions. You're muted, Evan.
I was waiting for Mr. McGee. I wasn't listed as a witness. I was here to.
Is that? I guess I have to beg the indulgence of the committee also.
Boy, I guess I mean I did ask for a list of witnesses, and I don't know that that's necessarily fair to toss new witnesses in, but I'd leave it to the committee to decide. I'd just, if it was up to me, I'd say no. So, because he wasn't noticed as a witness. Is there objection to my ruling on that?
I support your ruling.
All right. No objection to the ruling. Then please do not. Please keep it to
okay
the main people and their witnesses, please.
Okay, Mr. McGee. Then perhaps you could answer a couple questions I have about the process as to how this motion came about. Who made the motion at the LNC meeting following the Grand Rapids convention?
I would have to check the minutes. Give me a second.
I think it was the national chair who handed his gavel over to the vice chair, if I'm not mistaken.
That's right. You are correct.
Okay. Did the national chair give any notice as to the structure or the rationale behind this motion? And perhaps you could give a synopsis of his arguments at the time he made the motion. That's kind of why I wanted Evan to talk, but.
Right, and that probably would be preferable because I was not the one that drafted that motion, so I can't really speak to what exactly the motivation was for the language used.
Okay, I guess I'm at a stop point now because I can't get the answers I wanted.
Sorry, Mr. Goldstein. Mr. O'Brien.
Sure. I'm trying to figure out if my questions were kind of previously asked. I guess these were kind of already asked, but I was going to specifically ask Mr. Michaela, when he became chair of the LNC, were there discussions of potentially disaffiliating LPNH at that time? I guess that was sort of answered by Mickey and Buller, but Stephen, if you'd provide more information.
Sure. I know that the censure motion that was passed, I believe in November, had some language tied into asking the LPNH to self-disaffiliate. At the time, the only conversations, or most of the conversations, were around social media and things of that nature, things that we believe harmed the LNC. And at that point, I engaged in some conversations with Mr. Kaufman and Mr. Weir, along with Vice Chair Paul Dar and our communications director over the course of several sessions, which I believe was done in good faith, which did get the memorandum of understanding, which lasted some period of time. And that was between the LNC and the LPNH, not necessarily the Libertarian Party membership and the LPNH. And I think we stuck to our side of the agreement for as long as that lasted. So as far as conversations amongst LNC members, there may have been some. I may not have partaken in them, but I know there's been rumblings about disaffiliation for at least since 2024, or at least conversations about the endorsement of Donald Trump at the time and concerns about that.
Fair. Were you on the LNC in November of 2024, like when the endorsement happened?
I was.
Was there any discussion at that time?
There was discussion amongst some members. I remember at the time during that LNC, or I guess it was the same LNC, but during that year, before I became chair, there was some discussion that if something would come up, I know there were some members that said they would vote for a motion to disaffiliate LPNH. Many of those members are no longer on the board, and I don't recall conversations after that, at least not until November of regarding the social media issues in November of 2025.
Fair.
So that would be the only other time.
Understood. Trying to think of the way to phrase this question. Would you characterize the former chair, the chair of the LNC at the time of this endorsement, would you characterize Ms. McCardle as having potentially endorsed Donald Trump, even in some way?
Well, I think she disavowed our candidate, Chase Oliver, and essentially told people that the strategy was to take votes away from Joe Biden in order to secure a Trump victory, in order to try to make concessions with the Republican Party, which I believe is a de facto endorsement. So yes, I would characterize it as a soft endorsement, although I would argue it was pretty explicit for many of the people that would expect a national chair to endorse their candidate, regardless of whether or not they like them. I think it's important to stand behind the product of the organization and the will of the body that enables you to have a candidate. And so I think that was not very smart on her part. So yeah, I think it was an endorsement in a sense. Yes.
So on a scale between Chase Oliver's "the gun would go off" and like Bill Weld's I vouch for Hillary, somewhere further along, somewhere closer to endorsement.
Yeah, I mean, I think when you disavow your own candidate and tell people you essentially want the other side to win, it's essentially an endorsement.
So I apologize for this line of questioning also probably seems like irrelevant, but I'm just kind of understanding that the leadership of the LNC at the time of this endorsement did not seem indicative to necessarily want to take action on LPNH's tweet at that time. Or
I would say that is correct.
Okay. Lastly, so you had that agreement with LPNH regarding online decorum or how tweets or whatever the specifics were of it. How long would you say that agreement lasted before you feel that one of you deviated from the agreement?
That's a very good question. I think that the LNC stuck to its part of the agreement, at least for some length. I'm not sure when that line would have been crossed. I'm not sure when that line was crossed in the mind of the LPNH, because that was an agreement between the LPNH and the LNC in order to try to come to terms on messaging. And this was a voluntary agreement, essentially to lower the temperature in the room when it came to some of these tweets that I felt we felt rather that they got the LNC in hot water, or they got candidates in hot water, even candidates that weren't from New Hampshire. I know candidates, at least one candidate in New Hampshire that says they didn't want to run LPNH because they would lose 10,000 votes due to the association. So I believe they're running independent. And this unfortunately hurt candidates in other state parties as well, where I felt the LNC had to take some action and try to assuage some of those concerns by coming up with some ideas that we could try to. I'll give you an example. If the LPNH put out a tweet making an inflammatory statement, it would at least have a follow-up to explain why, X, Y, Z, it has to be that way. Or the suggestion was made, if it doesn't have to be talked about, then why talk about it? But we came to some terms and included not personally attacking members within the party, and so on and so forth. And as long as the LNC, or really not even members of the party, but members of the LNC, because I can't control what everybody in the party does. So I don't know when it fell apart. I think it was done in good faith. But it sounds like they thought it fell apart at some point. I couldn't tell you exactly when that would have been, but
Fair.
maybe a couple months after.
All right, thank you. I think that's the last of my questioning for now, so I'll yield to the next person. Thank you.
All right, Mr. Dixon.
Thank you, Mr. McGee. I have more than one question, but I'm going to ask my first one and pass the baton. If no one picks it up, I'm going to keep it. All right. Would you agree no notice was given to LPNH prior to this motion to disaffiliate?
So when you say notice, you mean notice of the motion, correct?
Well, I guess that's arguable. Would you agree there was no effort made to say, hey, LPNH, we may disaffiliate you?
I would argue that's false. I would argue that the censure motion itself, given the text, actually put them on notice that disaffiliation is potentially on the table.
Okay, so you're saying the censure motion was notice that they should expect something, but there wasn't anything formal saying, hey, we're planning to do this, you better prepare, right?
That's correct.
Okay. Now, in the minutes of the meeting on May 25th, this was the meeting where the motion was passed. It says the chair previously submitted a proposed agenda as follows. And in the agenda, item J was LPNH disaffiliation. So
that is correct.
So was it what, an hour between adjournment of the convention and commencement of the LNC meeting? Roughly an hour or maybe two?
You are correct. It's an hour.
So within that hour, the chair sent out an agenda to all the members of the LNC, and they would have, if they read it, they would have seen item J, LPNH disaffiliation. Is that correct?
It was sent out. I don't know at what time it was sent out, but I know it was available prior to the meeting being called to order.
Are there any LNC members that are LPNH affiliated people?
Well, not necessarily directly affiliated, though you could certainly argue that both Mr. Shaw and Mr. Ford, as the region rep and alt for the region that contains New Hampshire, would be considered, at least in some sense, a representative of New Hampshire.
Okay, let me ask one more, and then I'll see if I'll pass the baton to Jeff. This may be a tangent. It's really our focus should be interpreting the laws, but this is on my mind as somebody who's been on the LNC before. Typically, the meeting immediately after the convention isn't meant for substantive motions. It's, hey, everybody, here, introduce yourselves. Let's talk about when our next meeting is, what should be on the agenda. Unless there's some sense of urgency. Was there some sense of urgency that this disaffiliation motion needed to happen right then?
I mean, I can't speak for the entire LNC, but what I will say is that certainly there were some members that I talked to who, again, had been discussing this for over 6 months. And because of the provision in the bylaws that doesn't allow the committee to exercise that power within 6 months of a national convention, this was the first opportunity at which the LNC could exercise this.
Right. So in the hypothetical,
I would agree it's not normal for the LNC to exercise such a power at what is ostensibly a pro forma meeting. It doesn't prohibit it either.
Right. That's when I asked Mr. Hewitt the hypothetical where there was clearly a case of urgency and the LNC needed to respond to get control of the situation. There was nothing like that here, right?
Not as posed in your hypothetical, no.
Okay. I'll pass it to Jeff.
Well, I'm not sure I really have a question. What I have is a point, having been national chair. Yeah, your first meeting as a chair, you start with nothing. And the first thing you have to do is present an agenda. That's the chair's job. If the chair says, I've got notice on this, it goes on the agenda as an item with prior notice. Doesn't necessarily mean it's gone out to everybody on the committee. And then you go and you review the agenda and you approve the agenda. So it's not like, I'm sure that was followed, because that's just standard practice at any LNC meeting I've ever been on. And I'm sure that Mary could attest to that as well, having been in that exalted position like me. So that's one thing. But the thing I'd like to say is, yes, there was probably a majority of LNC members, in my opinion, that felt that disaffiliation was the appropriate action to take, but it wasn't 3/4. And a lot of those people carried that with them for that period of time. Did they have a little bit of built up resentment and anger and finally say, let's take advantage of this? Yeah. I don't, however, think that that's something that in itself is indicative of any kind of attempt to like hoodwink anybody. It came out. They had the opportunity to not put it on the agenda. They had the opportunity to speak against it. The people there had the opportunity to say, let's defer this. Let's do it. Let's have some investigation. Maybe politically it might have been better to do that.
Mr.
But
Neal.
surely that was completely within the realm of what would be considered pretty normal. I mean, look, the number one thing that DLNC has to do on its first meeting is to fill the committees that are required by the bylaws. Some can wait, bylaws and platform and commission oversight and stuff like that, but other ones have to be populated immediately. I mean, that's, in my recollection, that's what always the first LNC meeting is for. And I'll shut up now.
I was going to ask if you had a question, because it sounded like you were making a statement.
No, I don't. I said I don't have a question. I just want to say something.
Okay. All right. This is Q&A. Ms. Jingle.
Well, Jeff's comments brought this to mind. It sounds like some people had this cooking for a while. Some people on the national committee. I don't know what the division is.
I'm gonna interrupt you real quick.
Yeah.
Is this a statement or a question for?
No, it's a question. It's a question.
Okay. All right. Making
It's
sure.
a question for Mr. McGee. And Mr. Nicola could also answer, but so there have been some references in some of the amicus briefs about actions taken or not taken by the convention having to do with New Hampshire. Mr. McGee, is it your feeling that, okay, you've got these people that are already cooking for 6 months or whatever. Now, are the people that are now at the convention getting more stirred up? In other words, I guess what I'm asking is, did you have the impression that it was a campaign pledge for people running for the national committee that they would take care of this as soon as possible? Question mark.
Certainly, some candidates of the LNC made that explicit. I was not one of those people, but there were several members of the committee or people running for the committee that made that a part of their, campaign.
Okay. Now, I wasn't there, so that's why I'm asking, because I don't actually know what was going on behind the scenes or even in the scenes, whatever. Thank you.
Mr. Dixon.
Thank you. Mr. McGee, there is an argument made in at least one of the maybe more, that LPNH was seated as a delegation at the convention. And that presumably the credentials committee could have raised an issue and say, hey, delegates, they violated 5-4. It's up to you whether we seat LPNH. The point is, nobody on the convention floor opposed the seating of LPNH as a delegation, and therefore there's an argument that the LNC is overriding what the convention delegates did. Can you speak to that argument?
Sure. I, I think part of the problem with that framing is that the credentials committee, if the LNC is not empowered to disaffiliate an affiliate within 6 months of a convention, certainly I think you would be able to argue that a credentials committee can't thereby do the same thing.
Okay. Maybe I didn't follow that entirely. You're saying that the convention, do you believe that convention delegates can have more power than the LNC? The LNC is there to do the duties for 2 years, but when you have a convention, the delegates really have the power. They're the ones who can change the bylaws.
Correct. But
All right.
It,
So
again, this may be contentious, but there's actually no actual provision that I know of, at least directly, where the convention is actually empowered to do so.
Right.
Right. There was one suggestion that the delegates move to disaffiliate on the floor, and I don't believe that's the case. I don't think that happened, but that could have happened. The delegates on the floor could have said, "We disaffiliate LPNH." Would that have stood?
I think that's a real question that I don't have the answer to.
And if they did, we might be in this whole thing of, hey, we need a Dixon committee and all that, but I'm not even sure the bylaws provide for that. So I'm not sure what the answer is. I just wanted to see what your interpretation was.
I think honestly that could go either way.
Okay. Could I keep the baton and keep asking questions? Do I have time?
I'm muted again, talking to myself. I see no other hands raised, and therefore, Mr. Dixon, if you have additional questions, go ahead.
All right. Not too many more. Let me make it easy. Mr. McGee, is disaffiliation a disciplinary action?
In the context of Ronner Section 63?
I'm saying this action that you took, is it disciplinary? Does Chapter 20 of Roberts apply?
I would argue in the context of Roberts, no.
How could we resolve this? Because obviously Mr. Hewitt has a different interpretation. What should we look at that will give us this answer and give us the proper interpretation?
Well, I think the way you get the proper interpretation is by looking at Article 5.6 as written and not importing external standards not written explicitly into the provision.
All right. This is a different point. I had asked Mr. Hewitt about the applicability of case law. And I think in your brief, you mentioned you had some references and there's several other, Miki. What is your recommendation on how we should look at case law that's external to our own bylaws?
I think certainly in cases that are similar, that they could be used as a way to reason through how to figure things out. However, I don't think that external case law is in any way binding on this committee's decision.
Should we exclude anything that, for example, a Delaware case that seems to apply only to entities in the state of Delaware? Should we ignore that?
If it doesn't really apply, if it's not really a good fact pattern match to the case at hand, it probably should not be relied upon.
All right. I think I only have two more questions.
Keep on going.
Okay. If we come to the conclusion that the Trump endorsement is clearly a cause, and we understand the nature of cause, and there's no need for investigation, and it's clearly covered in 5.4. The other two causes, which have to do with social media posts and treating our candidates, they're not called out in 5.4. So the cause is not really in the bylaws. Should we, I guess my question is, should disaffiliation only apply to a violation of national bylaws, or could we have excluded the Trump endorsement and just say the tweets alone were bad, even though there's nothing in 5.4 that says you can't do that?
Well, I guess first I would argue that 5.4 actually says that you cannot do that, because the very end of 5.4 states that no affiliate shall take actions that are contrary to the statement of principles, which some of those tweets did.
So you're saying the statement of principles, and in the statement of principles, there's the clause about we're not violent, and some of the tweets alleged violence. So that was a violation of the statement of principles, right?
Yes. In the opinion of the LNC, yes.
Okay. Here's my last question. This argument about the compound vote, that there weren't separate votes on each item. Where should we go to resolve that question?
Again, as I stated in, I believe it was one of my amicus briefs, but again, any member that had a concern had a direct remedy at the time, and that would have been to move to divide the question under Roberts. I believe it's Roberts 27. Don't quote me on that. That if that was seen as legitimately being in doubt, that should have been the course of action of any member genuinely concerned about that sort of a threshold argument.
So your interpretation is there was no motion to divide, so we should interpret 3/4 to apply to every single cause, right?
That is the position I'm arguing, yes.
All right. Those are my questions.
Does the committee have any other questions for Mr. McGee, the representative of the respondent LNC? All right, I'm not seeing any. I actually had one, but I've lost it in my note taking. If you can give me just a moment here. Or actually,
I give you time, Ken.
I actually think Mr. Dixon did hit it already. Endorsements at statement of principles compound. Case law. Actually, Mr. Dixon did cover it, so I think we're good there. I don't have anything either. So if no one has anything else, we had a break scheduled here. I think we can take a shorter one than 7 minutes. We would go to 5-minute close by the LNC, and then followed by last statement, 5-minute close by LPNH, the appellant. That sound good to everyone? We take a couple of minutes here. Okay. All right. Good deal. So let's take a couple minutes. We'll come back. I'm going to just go ahead and say 11:06 since we're already past the 3 mark. So about 2.5 minutes. And we'll get started on the closing statements. Don't forget to mute and turn video off in case you. This is the less than 1 minute warning. All right, that is time. It's now 11:06 p.m. Eastern Time. I do have a timer out here with 5 minutes set. I really want to keep this to 5 minutes. These are closing statements, starting with the LNC as the respondent. When you are ready, I will start my timer.
Thank you. Members of the Judicial Committee, I will keep this brief and focus on what actually decides this case. The endorsement is conceded. In November of 2024, Disaffiliate's Executive Committee endorsed a candidate of another party for president in direct violation of Article 5, Section 4. This has not been disputed, not in the appeal, not in any brief, and not tonight. It is specific, it is dated, and it is sufficient on its own to sustain the disaffiliation under our bylaws. Everything else you have heard is an argument about what should follow from a fact no one contests. Article 5.6 of the national bylaws asks the National Committee to specify the cause for revocation. It does not ask for a trial. It does not ask for the procedure this party uses to remove an individual officer, a procedure our own drafters of the bylaws wrote elsewhere in Articles 6.7 and 7.5 for officer removal, as well as separate language that was used for recall of vice presidential and presidential nominees. That choice is intentional and deserves respect. 8 months before the censure vote, LP New Hampshire received a formal censure and an explicit invitation to correct course voluntarily. It declined that invitation. And the conduct the censure addressed did not stop. An organization that extends a warning and watches it go unheeded is not required to extend it forever. I would ask you be cautious about any rule that says otherwise, because that rule would punish every future national committee that chooses initial restraint and then reward none that do. You heard tonight about the process this party used once before in the LP New Mexico situation. This account is not disputed because there's no need to. The LP New Mexico case turned on facts that were genuinely contested, whether a convention was properly noticed, whether a board held authority its members never gated, and that dispute required investigation because there was something to investigate. Nothing in here is in that sort of doubt. What remained for the National Committee to decide regarding LP New Hampshire was not whether the endorsement happened, but what should follow from it. And that judgment belongs to the National Committee first, and then to the Judicial Committee on review. The endorsement was a violation the day it happened. The official communications of New Hampshire were consistently in violation. The warning that followed went unheeded. The vote that followed was properly specified, properly noticed, and properly taken by the substantial margin our bylaws require. As such, we ask you to affirm the decision of the National Committee. Thank you.
Mr. Molman, you're muted, I believe.
I will someday learn to use a computer. You know, hey, it's only what I do for a living. Thank you for that. Mr. Hewitt, you have a 5-minute close as well. You can give it yourself, or you can hand that off to any of your witnesses as you choose.
Well, some quick factual corrections. Region 6 Rep Alpha Shaw did not, I just spoke with him. He did not receive any agenda before the LNC meeting disaffiliating LPNH. He has checked. He didn't receive any electronic communication. He was given a paper copy of the agenda in the hallway as he walked into the LNC meeting. Austin Martin has also confirmed he was never provided the agenda in any form until he sat down at the meeting. And in the convention, not one person ran on LPNH disaffiliation. They did not say they wanted to disaffiliate LPNH in their speeches, even if they may have said that in some signal group somewhere. Mr. McGee said that you should just look at the text of Article 5.6. Don't look at all this outside stuff in Robert's rules. But Article 16 of the bylaws says the rules contained in Robert's Rules of Order shall govern, where they're not inconsistent with these bylaws. So if Mr. McGee doesn't want them to bear here and wants the LNC to just have unfettered discretion in how it interprets the four corners of the bylaws, he should remove Article 16 from the bylaws. I think the LNC is between a rock and a hard place. The only thing even they claim was some sort of prior notice was this social media censure in 2025. But the disaffiliation motion on social media could not possibly be any more vague or more defective. If any part of a decision upholding disaffiliation here is reliant on this totally vague social media language, there is no reason in the future that any LNC should ever spell out with specificity what the cause of disaffiliation is. They shouldn't do that because spelling out with specificity the cause helps the appellant prepare their defense. You put them at a disadvantage if you're allowed to not specify. So if that's the precedent we set, you can just disaffiliate at will when you don't like an affiliate. You just need to wait until you get the votes. There's a right way to do this. This committee can write an opinion saying our decision is not with prejudice. LNC, you have another bite at the apple. Just do this for cause and spell out specifically what the reasons for disaffiliation are. We can have an investigative hearing and we can look at all the tweets and we can make a reasoned decision about what to do. This rescission argument is neither here nor there. 35:2 in Robert's Rules, which talks about rescission, that is basically a limitation. It's a bunch of limitations on rescission because rescission is disfavored under the principles underlying Robert's Rules. So there's a heightened 2/3 standards for rescission there. That doesn't mean that any vote that rescinds any prior action only requires a 2/3 vote. Removing an officer is rescission. And 61:16 says you can remove an officer with a regular rescission vote if they are not a fixed term officer. If they are a fixed term officer, it's a for cause removal and you go through a process. Lastly, I want to give an analogy. There's a lot of stuff in Robert's Rules 61 through 63 about for cause. It's very extensively defined, but it's true. 61 through 63 mostly talks about for cause removals of members and officers. Now, what if, hypothetically, Robert's Rules had all the same stuff in these chapters, but it was just about members? It only explicitly addressed members and for cause in that context and not officers. Would we then seriously have a JC hearing where we considered an argument by the LNC that changing the context from expelling a member to removing an officer, that somehow means the term for cause is completely different? It's a completely different concept now. And in fact, would we hear arguments that that means these general principles in Roberts about for cause, they have nothing to say here? And in fact, would a JC member say that if we take the concept of for cause in member expulsion and we carry it over to officer removal, that's actually bullshit to import that concept from Robert's Rules? I don't think we would. For cause in any authoritative source includes a basic, fair disciplinary process under Robert's Rules, which is part of the bylaws, or in this committee's decision under Phillies. So the JC should reverse disaffiliation. And if it says it's doing so without prejudice, and the LNC appoints an investigatory committee and checks the boxes and does this right, we can cross that bridge when we come to it.
All right. Thank you very much, Mr. Hewitt. Thank you to everyone who was on tonight. Thank you to everyone who watched. I guess. I don't know why people want to watch the inside baseball of this. I hope it was only party people, but none of us want to be here. We have 10 days as a judicial committee to vote and come up with a preliminary decision. And then that's per our rules. And then up to 30 days past this to publish our decision. So just so everyone knows what's happening next. I see Dr. Moulton has his hand raised. Yes, Dr. Moulton.
It's my understanding under the JC rules, we have the option of deliberating in open session. If enough people vote to do that, would this be an appropriate time to make that motion?
I think we could make that motion here, yeah. Actually, to come to think of it, I think this would be the only place that we could really do that.
I would like to make that motion.
All right, Dr. Moulton, you are motioning that we deliberate in open session?
Yes, I am.
Okay. And that, if I remember correctly, takes 2/3. I believe. Can you, do you have that in front of you by chance?
I don't have it right in front of me. I can go
I
look
was
it
not
up.
prepared for that motion, so.
I think
sorry.
it would be majority unless you're suspending a rule.
No, it's explicitly in the rules, so it's definitely not majority, but I can go look it up what it is.
So let's put it this way. The hearing portion has ended. So anyone who is not on the committee is welcome to leave. You're not going to miss anything other than procedural, but you're also welcome to stay. We will continue the recording. We're not going to stop until this meeting closes. So 100% up to you. I know people have things to do, and it is 11:16 on the East Coast anyway, p.m. But I just want to make sure that everyone understands where we're at. There's been a motion made. Dr. Moulton's made a motion that our deliberations would be an open session rather than the default, which is executive session or closed session.
Mr. Chair, I've
Yes.
looked it up. It's JC Rule 8.4 says the committee may by a 2/3 vote deliberate in open session once the hearing concludes. Otherwise, deliberations shall be in executive session.
Okay.
My motion is that we deliberate in open session.
Okay. So
What is the distinction between those two? I know executive session is like private, but like open session is like.
The question is, do we keep the YouTube going and let people see us deliberate, or do we deliberate in private?
But I don't know about you. I don't plan on deliberating this evening.
I don't either.
That was my question.
Oh, okay. It could be another time then. That's
I'd like
fine, too.
I'd like to reread through everything, like, and compare it to what we just heard.
Yes. So
just talk, Pat. Just talk.
Yeah, I'm doing this. I'm trying to do this the right way with my hand
you're fine,
raised.
Mr. Dixon, go ahead. Sorry, I'm trying to take
All
notes
right.
and I'm trying to, yeah.
So I have to ask Chuck, are you saying that we cannot have any executive sessions for the next 10 days, or that we will have some? I'm just trying to understand the logistics, because if you're saying all of our deliberations are open session.
No. What I was trying to do, and maybe the committee doesn't want, I mean, it's a high bar. Maybe the committee doesn't want to do it. I mean, there's a distinction between the vote and the opinions. The opinions are going to take like a while to write, clearly. But I didn't know whether we wanted to discuss things and then have the vote in open session. That was what I was proposing. But
okay.
I can withdraw my motion if the committee doesn't have an appetite
All I'm
for
trying
that.
to do is understand what your motion is. It sounds like your motion is when we get to a vote, that will be an open session. Deliberations would still be executive session.
Well,
and when we
I
do
would-
the open session, it would be just like this, where YouTube can see, but they can't talk.
Right. Our rules just say that the committee may by a 2/3 vote deliberate in open session once the
Chuck,
meeting concludes.
how was this done in prior JCs that you served on?
No one wanted to do open session and do prior JCs. This seems like, to me personally, a case that deserves to be deliberated in open session, but that is not the usual procedure for sure.
I suggest we table this and discuss it offline and take a vote.
Yeah.
Because we're all kind of exhausted.
That's fine with me. I will withdraw my motion at this point.
Dr. Moulton, I'll just note, even though you've done that, I'm not opposed to it, but I want to get the details of when we're doing all, get it a complete noticed, this is what we're going to do, and put it out before we do the thing. So we have 10 days, which means we should probably figure this out tomorrow or the next day. I believe, if I remember correctly, the committee, there was talk about having a meeting on Thursday between some members.
No,
I'm out.
Okay.
I'm out.
Okay. We'll figure that out. All right. We have 10 days. That's all I know. We have to figure this out in 10 days. So
I'm clear on the 13th.
What's that?
I'm clear on the 13th if we want to do it.
That's what I said.
Let's
10 days.
let's figure this out offline.
I
Yeah.
am not.
Let's figure this out offline.
Yep. We're going to take this offline because we're not going to settle this right now. So what I'm going to do is say thank you to everybody who tuned in. Thank you to those who participated. Not exactly the best meeting that I'd like to chair, but we did it, and we will follow the rules as they are written. We will get a meeting. We will get a ruling in 10 days. We do not have to expose that ruling to the world if we don't want to. But given what's going on, we'll see what the committee decides. I mean, it's up to the committee to decide all this. So we will definitely have written decisions with everyone's names attached in 30 days. That is a rule. So no matter what, in 30 days, we will have, everyone will know everything. So there you go. And with that, I don't think there's any other business to do tonight except adjourn.
Good night, everybody.
Good night.